2022-01200. That is people of the state of Michigan versus Javon Smith Dobbs. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Aaron Robinson, Assistant Public Defender for Mr. Smith Dobbs.
And is you are Mr. Smith Dobbs? You can come on. You can come up here.
Sorry. Okay.
And sir, you are Javon Smith Dobbs. Is that correct?
Yes, ma'am.
All
Yes,
right.
sir. I'm sorry.
Thank you. Mr. Brodowitz, is the time set for a jury trial? How are we proceeding?
Yes, Your Honor, as you stated, today's date and time set for jury trial. However, I believe there is a jury trial that will be running today that has priority. So at this time, the people would ask for a new date as the people's witnesses have appeared. We're ready to proceed.
All right. Ms. Robinson, is that your understanding?
Yes.
All right. So we'll get a new date for jury trial.
June 27th.
June 27th at 8 a.m. Any questions on that June 27th at 8 a.m. date, Mr. Brodowitz?
Nothing from the people, Your Honor.
Ms. Robinson?
No, Your Honor, thank you.
All right, Mr. Smith Dobbs, we'll see you back here on June 27th at 8 a.m., okay?
Yes, sir.
Thank you.
Okay. Can you stand for your
Let's
go on the record. Oh, yeah.
Yeah.
Yeah, Aaron, sorry, I should probably introduce Taylor White. I don't think we've had.
No.
Yeah, Aaron, we're going to do this one.
Okay.
So.
And then as soon as Aaron gets back, we'll put Cornell on the record. That's all right. Galaxy there. I am. On the Galaxy cell phone in the car, would you identify yourself?
Good morning. My name is
Sir?
Kenneth Goodman. Yeah,
Kenneth,
can you hear me? Kenneth Goodman.
what's your what Goodman?
Goodman, yes.
All right, you're here for your 8:30?
Yes, I am.
All right, stand by. You're in the right
Okay,
room.
thank you. All right.
Can I get a PPO over there? Yes.
Ma'am, are you Alexis Duncan?
No, my name is Latour Riggins.
Your name is, what's your last name, ma'am?
Riggins, Reggans.
What case are you here on? I don't have you on my docket.
I'm supposed to be in Tony Flores' courtroom for Joseph Vitale.
Joseph? Do you have a
Oh,
case
I went on
number?
the wrong day. I'm sorry.
Wrong day?
Yep.
All right. We'll see you on the right day.
I'll see you tomorrow.
Okay. Mr. Goodman, are you there? Mr. Goodman, are you there? Is this the problem you were having? Is
Yeah.
that some type of mute or he's on audio? He's connected. Mr. Good.
Right.
Yeah, obviously.
Yeah.
Mr. Goodman, you need to pull the car over. Mr. Goodman, you need to pull the car over. And we can't hear you.
Hello?
Mr. Goodman, you need to pull the car over. Okay. Like I am. No, we can see you're not.
Hello?
Mr. Goodman. Are you there?
I can bear, hold on.
Yeah, you're breaking up. Mr. Goodman, I'm gonna reset your pre-trial to be live in
I
person,
can't hear
okay?
anything. Hold on.
All right, well, it doesn't matter. Can you,
Just a second. I gotta. Oh my goodness.
resetting plea live, yeah.
Can you hear me?
I barely, Mr. Goodman, you're breaking up. I'm gonna reset this plea so it's live in person.
Why?
Because I can't hear you and you can't talk to your lawyers and you're driving while we're
I'm not driving.
trying to
Judge.
get a plea.
I'm pulled over. I'm not driving.
All right. Both lawyers have indicated they've tried to talk to you and you've not been able to be talked to. So
I couldn't. Was that Taylor Wick? Was that my lawyer?
that's your lawyer and Miss Robinson's your lawyer both.
I was trying to talk to Miss Wick and I kept saying I could see her, but she wasn't saying anything.
Yeah, that sounds like a lawyer to me. All right, Mr. Goodman, what I'm going to have you do is I'm going to have you stand right there. I'm going to put Miss Wicks back in a room with you.
Okay.
And don't drive. Pull over. I can hear you. We're going to have put Miss Wicks in a room with you, and then we're going to come out and put it on the record, okay?
Okay, Judge.
All right. So when Miss Wicks joins us, we're going to put her and Mr. Goodman in a breakout.
I'm still on.
All right.
And we can go on Mr. Edmund Jones, Judge, he's here.
Better off if we just move that forward. Peace.
Always turn
Jones.
the back on the morning.
All right, we're ready on Mr. Jones.
How you doing, son?
Good. On the record in docket 23-01682, people of the state of Michigan versus Edmund Jones. Will the parties please introduce themselves for the record?
Jeff Prados on behalf of the people, Your Honor.
Edmund Jones.
Yes, sir.
All right, this
The people have made an offer in this case, and that would be the defendant plea to count one domestic violence with 7694A if eligible.
and Ms. Robinson.
We're just gonna set this for final pretrial and jury trial.
Okay. June 27th at 8:30 for final pretrial.
And the jury trial July 18th.
And the jury trial will be July 18th at 8. The final pretrial, Mr. Brodowitz, have your witnesses here. And set live, so that'll be live in person for final pretrial. Jury trial is set for July 18th at 8 a.m. Anything else for the record in docket 23-01682, Mr. Brodowitz?
Nothing from the people. Your Honor.
Ms. Robinson?
No, Your Honor, thank you.
All right, Mr. Jones, we're all set. Thank you.
And just a run. We're gonna get this meeting with the next meeting. Okay, just make sure
I'll wait outside.
Oh, you just wait right here. This should be just a quick second, right? You are? Yeah.
Push. Turn it, push.
There you go.
I'll ask John who is in a second.
John Knight.
I'm going to identify John. Sir, labeled John, would you please identify yourself?
I'm John.
John, what's your last name, John?
Right?
Yeah, you're here for your 9 o'clock?
Yes, sir.
All right. Stand by, you're in the right place. Ms. Wicks, did you have the opportunity to speak with Mr. Goodman?
There must be something with the breakout room, Your Honor. We still couldn't hear each other really, but we got it done. There will be a plea this morning.
All right, good.
Thanks.
All right. So, Mr. Goodman, can you hear me?
Yes, sir.
All right. So we're on the record in docket 23-01362, 23-0163, and 23-01364. 63 and 64. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Taylor Wicks, Assistant Public Defender, filling in for Lauren Sutter on behalf of Mr. Goodman.
And sir, you are Kenneth Goodman?
Yes, sir, I am.
Okay, and you can hear me all right, Mr. Goodman?
As good as I can.
All right. This is the time set for a plea in the matter. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor, I believe we are set for a plea here today, and that plea would be, I believe it was to count one dog at large with an agreement to pay restitution to the victim, Mr. Celestino Bernal. That restitution number, which I received from
Hold on, just 1 second. So we have 3 files. Which file would he be pleading to?
And I believe that would be 23-1362.
62. The first file, would he be pleading to the count 1?
Yes.
Okay. 2. And this is all on the same ticket. It looks like it was broken up into 3 different files. Okay.
Yes.
Plead to count 1 dog at large. And then dismiss counts 2 and 3, or I would be files 6-3 and 6-4.
Yes, Your Honor.
Okay.
Counts 2 and 3 on the ticket, and 6-3 and 6-4 case files.
23-01364. Dismissed. All right, and then continue, Mr. Brodwitz. I'm sorry, I just want to make sure I had that right.
There you are. And yes, then there was an agreement for a deferred sentence for the defendant to pay restitution. That restitution number, which I received from the victims in this matter, would be $548.58.
Okay, so it's $548.58 to
Mr. Celestino Bernal. I will spell that for you if you want. Your Honor.
Okay.
That's CELESTINO and then BERNAL.
Is there any agreement as to the 90-day misdemeanor as to the jail time or immediate sentencing or anything along that? So we'd actually give you a sentencing date. Is there agreement to no upfront jail or anything along those lines?
There was not, but I don't believe that was ever. I believe we would be asked, no upfront jail.
Okay.
Once restitution is paid, I believe it was the people's intention to dismiss it then.
Oh, so deferred sentence. And did you have a framework as to how long you wanted that? How long?
I'd be asking for 11 months, Your Honor.
Okay, so a year. Yeah. So a year deferral. All right, so Mr. Goodman, I'm going to restate that for the record, and your attorney can correct me. You're going to plead guilty to count 1, file 23-01362. Counts 2 and 3 are to be dismissed. Likewise, I'm going to dismiss 23-0163 and 64 as the files out of the same ticket. There's an agreement to pay $548.58 to the victim, Celestino Bernal. And we're going to do this as a matter of deferred sentence. So this will be deferred for 1 year to give you the opportunity to pay off the $548.58 restitution and then revisit this in a year. Is that your understanding, Mr. Goodman?
All count 1, 2, and 3 will be dismissed once I make my payment, right? That's what I'm understanding.
I have 2 and 3 would be dismissed. Would count 1 also be dismissed?
At the end of deferral.
Correct, Mr. Goodwin. Counts 1. So I would indicate that at the end of deferral.
If restitution is paid.
Deferral. If restitution paid. Count 1. File 23-01362 would also be dismissed. So that is correct, Mr. Goodman. If in a year, if the restitution is paid as a part of the deferred sentence, count 1 or the file 23-01362 would be dismissed. Is that your understanding, Mr. Goodman?
The complete file, 1, 2, and 3, yes.
Correct. All right, so I'm going to walk you through your misdemeanor rights in this misdemeanor plea. All right, sir?
Yes, sir.
All right. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have the witnesses against you appear at trial. You have the right to question those witnesses against you. You, of course, are represented by Public Defender Taylor Wicks today, and she would be present at trial to cross-examine any witnesses and contest any charges brought against you. You have the right to have the court order any witnesses appear in your defense. You have the right to remain silent during the trial. You have the right not to have that silence used against you, and you have the right to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than the stated plea agreement or threats that it was not your choice to plead guilty. You'll also be giving up the right to appeal any issues from trial because you won't be having a trial today. You'll be pleading guilty. Is it my understanding you intend to waive your rights to a misdemeanor trial and plead guilty today, Mr. Goodman?
Yes, Judge.
All right. I'm going to have you raise your right hand so I can see it. Okay, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do, Judge.
All right. I'm going to bring your attention to on or about April 27th, 2023 at the offense location of 4920 City of Lansing, Ingham County. Were you responsible or in charge of a dog on April 27th, 2023 at that Ballard City of Lansing address?
Yes, Your Honor.
All right. And was that dog was that Debo or Don?
That was both of them.
Okay. And at that time, were they running at large?
Oh, they got into the neighbor's yard.
Okay. So they were loose, and
Yeah.
you were responsible for them at that time, or you were you were a guardian of the dogs at that time. Is that correct?
Yes, Your Honor.
All right. Anything for the factual basis, Mr. Brodowitz?
Nothing from the people, Your Honor.
Ms. Wicks?
No, thank you, Your Honor.
All right, I find the factual basis to be understanding, voluntarily, and accurately made. And we will defer sentence on this file, on all three files, but especially on this file. Well, we dismissed those two today, so we'll defer sentence on this file. Restitution is $548.58 to be made to Celestino Banal, and we will set it for.
June 10th, 2024.
So we'll set the deferred sentence for June 10th at 2024
At 9 a.m.
at 9 a.m.
Okay, if I get it
All
paid
right.
before then, we'll just revisit.
Absolutely. If you get it paid before then, let Miss Wicks or Miss Robinson know. They'll let the prosecutor know, and we'll tell we don't need to have that hearing.
Okay, Judge. Okay.
And is that Wainwright Avenue still a good mailing address for you?
Yes, Judge.
All right, perfect. The restitution can just be made to the city, and then the city makes it to the
So
victim.
long as he has a pink
All right.
restitution.
So you have to fill out the pink restitution
Yep.
form. All right. All right, and you can make restitution to the city. We'll have the pink restitution form that'll indicate the number and the victim that it's to go to. All right, sir?
They'll send it to me in the mail?
Yeah, we'll send it to you. We'll send you the notice of hearing in the mail. That's at the Wainwright Avenue address.
Right. But I mean, as far as making the payments, just go down there and tell them what do I need to
Just
go down
come.
there and
You can either go online or you can come to the window and do it in person.
Okay.
All right.
Okay, Judge.
Anything else on the record in docket 2301-362, Mr. Brodowitz?
Nothing from the people, Your Honor.
Ms. Wicks?
Nothing from defense, thank you.
Mr. Goodman, do you have any questions of me?
So once this is all done, will nothing be on my record or nothing, right?
Correct. That's correct.
Okay, Judge, I'm fine with that.
All right, Mr. Goodman, you're all set. Thank you for your appearance today.
Thank you, Judge. Have a great day.
You too.
Thank you, Ms. Wick.
You're welcome.
We have. Sir, in the Ingham County Jail, are you Terrell Duncan or are you Demario Ross?
I'm Terrell Duncan, Judge.
All right, thank you. Stand by, you're in the right place, and we'll get a public defender for you.
Okay.
All right, Mr. Duncan, we're on the record in docket 22-02185. That is people of the state of Michigan versus Terrell Duncan. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Taylor Wicks, Assistant Public Defender, filling in for Aaron Robinson on behalf of Mr. Duncan.
And sir, you are Terrell Duncan?
Yes, sir.
All right. This time set for a pretrial in the matter. We did have a previous file that we handled, or files, I should say. I'll let you explain, Mr. Brodowitz, and I do believe we're adjourning this to after June 26th. Is that correct?
Yes, Your Honor.
All right, go ahead.
There was I do not remember the case number offhand, but there was a previous case, I believe from around 2019, involving Mr. Duncan that is before Judge Aquilina right now for sentencing. As part of the plea agreement in that case, Mr. Duncan was to pay restitution on this file, and then after sentencing, this file would be dismissed. Due to some failures to appear and some other delays, the sentencing has not yet taken place. However, it is scheduled for June 26th in front of Judge Aquilina. And after that sentencing takes place, the people would be dismissing this file. And so I would just ask that this be adjourned until after that June 26th date, and to allow the sentencing to go forward and the file to be dismissed.
All right. Is that your understanding, Ms. Wicks?
It is, Your Honor, and I do have that circuit court case number if you would like it.
Sure.
It's 20-77 FC.
All right. So, Mr. Duncan, we're going to adjourn this to after June 26th. Your sentencing date in front of Judge Aquilina is June 26th. And then what happens there at the sentencing will be dispositive as to what happens with this case. Do you understand that, sir?
Yes, sir. Can I ask you a question, Judge?
Sure. You can ask a question about the process. Don't ask a question.
Okay, sounds good. For the cop that I'm taking supposedly on the 26th, a part of the plea agreement. So
that would be in front of Judge Aquilina. That wouldn't be in front of me.
Okay, so say I wait on the PSI, the people to come see me for the interview. I have the interview. Everything goes fine. I go see Aquilina. Everything is thrown out. I know I have a bond. Your bond is like a $5,500, 10%. And in the event that she's like, okay, everything's thrown out, everything went down, he's good. Will I still have to stay here and wait for you to come see you again with that bond over my head, or will everything be thrown out as far as like I'll be good to go?
You do have a bond on this case, but I think you're remanded on Aquilina's case, if I remember correctly.
Yes,
So that whatever you need to finish up with her on the 26th is really paramount, because that's where the remand comes from, not from this court.
Exactly. So what I'm saying is, when I go in front of her and everything goes down, I'm saying everything's good, and say it gets thrown out a part of the plea agreement, will I still have to wait around to come back and see you, or will everything be over in front of her right then and there?
Just a second, Mr. Duncan. Wendy, are you planning on the 27th?
I am.
Okay, it's going to be set the next day. So in worst case scenario, you'd have to sit overnight, but it should get to the court before then. And this case should be dismissed before you'd have to post any bond.
Right.
Okay. All right.
Okay. That's a good question, Mr. Duncan. All right. Anything else on the record, docket 22-02185, Mr. Brodowitz?
Nothing from the people.
Ms. Wicks?
No, thank you.
All right. Mr. Duncan, you're all set. Thank you for your appearance today.
We need a time here.
Oh, we need a time.
June 27th.
June 27th? Oh, at 8:30. Okay. I didn't put the time down. At 8:30. All right, so June 27th at 8:30 for the will-be. Thank you for your appearance today.
Hey, Judge, I'm sorry, one more question. Earlier this week, I'm sorry, I get up out of here. Earlier this week, I came to see you. It was on a dry run. I went downtown, they didn't have me see you. And they gave me a paperwork saying I gotta come back on the 29th to see you. So now I got two different dates. I got the 29th and the 27th. So now, is there gonna be any confusion where, okay, the 27th comes, we've also scheduled to see him on the 29th as well? Because I got another date from you, like earlier.
It's got another hearing on the 29th?
No.
Yes, for the felony matter, but that I expect will be The felony matter that we adjourned last week, I expect that one will be dismissed at the same
Right.
time as.
I think both of those matters will be taken care of on the 27th. There is a 29th, but I think the 27th, we'd wrap up all the files on that date.
Sounds good.
All right. All right, you're all set, Mr. Duncan. Thank you.
All right, thank you. Have a good one, Judge.
You too. Let's see. So Ms. Kuthan's on Zoom.
Yes.
All right, Ms. Kuthan, we'll call your case. Cases, I should say.
Launching.
26.
Conflict of.
0603.
You don't have her.
Okay.
0948. All right. So we're on the record in docket 22-00948, 22-02202, 22-03116, and 23-00603. That's People of the State of Michigan versus Autumn Kuthan. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Aaron Robinson, Assistant Public Defender for Ms. Coogan.
And ma'am, you are Autumn Kuthan?
Correct, Your Honor.
And you can hear me all right, Ms. Kuthan?
Yes, Your Honor.
All right, this is the time set for a pretrial in the matter. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor. At this time, the people have made an offer, I guess, to globally resolve all four of these cases. And that would be for the defendant to plead to one of the cases as charged under domestic violence with 76948 if eligible. And then the other three cases would be dismissed.
And Ms. Robinson, comment?
We will be setting these for final pretrial and jury trial.
Okay. So I'll indicate for the record that offer was made. Offer made. And we'll be setting this for. So final pretrial is set for June 27th at 8:30. And that'll be live. Mr. Brodowitz, you'll have your witnesses here on June 27th. The jury trial is set for July 18th at 8 a.m. So for the record in docket 22-00948, it is set for final pretrial on June 27th at 8:30. That's a live pretrial or live in person, and jury trial set for July 18th at 8 a.m. I will make the following notes in the rest of the files. That's filed 2202, 3116, and 0603. Any questions concerning those dates? The 27th at 8:30 for the final pretrials and jury trial for July 18th at 8, Mr. Brodowitz.
Nothing from the people.
All right, Ms. Robinson.
No, Your Honor, thank you.
All right, so Ms. Kuthan, we'll see you on June 27th at 8:30 for your final pretrial, and then your jury trial set for July 18th at 8 a.m. Okay, ma'am?
Okay,
All right, you're all set. Thank you for your appearance today.
thank you. You have a great day.
You too. Yep. We're on the record in docket 23-0148. I'm sorry, 23-01468. People of the state of Michigan versus John Wright. Will the parties please introduce themselves to the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Aaron Robinson, Assistant Public Defender for Mr. Wright.
And sir, you are John Wright.
Yes, sir.
This is the time set for a pretrial in the matter. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor, at this time, the people have made an offer that if Mr. Wright were to provide a proof of securing the dog, that the people would dismiss the ticket for compliance.
Ms. Robinson?
Yes, Your Honor. So we would request a brief reset. Probably 2 weeks should be sufficient.
We'll give you, I'm not sure, but right around that 2 week time.
Whatever's convenient for the court.
2 to 3 weeks.
June 27th.
June 27th at 10 a.m. So, Mr. Wright, this has been adjourned to June 27th at 10 a.m. Make sure Ms. Robinson has any paperwork for that June 27th date. We've reset it for that time period. Okay, sir?
Yes, sir.
All right. Mr. Brodowitz, anything else on docket 23-01468?
Nothing from the people. Your
Ms.
Honor.
Robinson?
No, Your Honor. Thank you.
All right, Mr. Wright, you're all set. We'll see you on the June 27th date. Okay, sir?
Thank you, Your Honor.
Thank you.
Who's in the jail?
Mario Ross.
Mario Ross. You said Miss White is the. Miss White, we're going to call your case. You can unmute.
Okay.
All right. We're on the record in docket 23-01325. That's people of the state of Michigan versus Nadine White. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
And ma'am, you are Nadine White?
Yes.
All right. This is time set for pretrial in the matter. My understanding is that we have conflict counsel appointed, but there's some question as to whether the appointment made its way through. Mr. Brodowitz.
Yes, Your Honor. I guess is my understanding. Last time we were here, I believe it was 2 weeks ago, Ms. Wanji did appear in court stating that she had been appointed conflict counsel for Ms. White. However, even on the docket I printed out yesterday morning, Ms. Sutter is still listed as counsel. So I'm not sure where that's going, and I have not seen Ms. Wanji here yet today. So.
Miss White, have you had any contact with Ms. Wanji?
No.
All right. For some reason, your conflict counsel is not here today. So and you should be represented by counsel throughout the pretrial process. So what I'm going to do is I'm going to adjourn this matter so that just to give some time so that you can get with counsel and you can meet with conflict counsel. Okay.
Okay.
All right. And I assume there's no objection to that, Mr. Brodowitz?
No objection.
All right. So we'll adjourn this matter 2 to 4 weeks, whatever we've done.
About 5 weeks.
Let's see, it's assault and battery. Yeah.
The 27th, we're looking at the trial date, and then the next one's the 4th of July, and then judicial.
Let's do 5 weeks.
Okay, let me get the attorney changed, but it will be July 18th at 9.
July 18th at 9 for pretrial. All right, so Ms. White, we have adjourned your matter to July 18th at 9 a.m. That should have plenty of time sufficient for you to talk to Ms. Wanji and Ms. Wanji to talk to Mr. Brodowitz concerning this file.
Okay.
So we've reset it for that July 18th date. Is that Jolly Road address still good for you to get a mail?
Yes.
All right. So you'll get notice that July 18th by mail from the court. Anything else for the record in docket 23011325, Mr. Brodowitz?
Nothing from the people. Your
All
Honor.
right, Ms. White, you should be all set. We'll see you on that July 18th date.
Okay, thank you, Your Honor.
Thank you. Mr. Thomas, you're here for your 9:30?
Yes, Your Honor.
All right, are you represented by counsel today, or are you on your own?
I believe I'm on my own, Your Honor.
All right. I'm going to have you stand by. I may have you talk to the assistant prosecutor on the case, okay?
Yes, sir.
All right.
Gain on speaker.
All right, so we're on the record in docket 23-00959. That's the people of the state of Michigan versus Demario Ross. The parties, please introduce themselves for the record.
Jeff Bradowitz on behalf of the people, Your Honor.
Aaron Robinson, Assistant Public Defender for Mr. Ross.
And sir, you are Demario Ross?
Yes, sir, I am.
Right, you can hear me all right, Mr. Ross?
Yes, sir, I can hear you.
All right.
Sir.
This is the time set for a pretrial in the matter. Mr. Bradowitz, how are we proceeding?
Yes, Your Honor, at this time, the people have made an offer in this matter for Mr. Ross to plead to a added count 2 of retail fraud 3rd degree. That is PAC code 750.356D4. And that's a 93-day and or $500 fine. And then there's also a Killebrew agreement to 30 days in the Ingham County Jail with a restitution to Lowe's.
And restitution is yet to be determined?
Yes, I attempted to call the contact person from Lowe's yesterday, did not get a hold of them before I left the office, received a voicemail late last night from them. And so I will be in contact with them to get a restitution number.
All right. Is that your understanding, Ms. Robinson?
It is.
All right.
We're reserving restitution.
All right, sure. So I'll restate that for the record. It is, we're adding a count 2 of retail fraud in the 3rd degree, which would be less than $200. That is punishable by 93 days and or $500. There's a Killebrew agreement of 30 days, a cap of 30 days in the Ingham County Jail. Is that my understanding, or is it 30 days?
Yeah, just, I mean, a cap.
Yeah, just straight
The
up.
cap of 30 days
Cap of 30
Killebrew
days.
agreement, okay. And then restitution to be made to Lowe's once it's determined. Mr. Ross, is that your understanding?
Yes, sir, it is.
All right. Ms. Robinson, may I inquire of your client of his misdemeanor advice of rights?
Nay.
Okay. Mr. Ross, you understand you have the following misdemeanor rights in this case, and I'm going to walk you through those. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have the witnesses against you appear at trial. You have the right to question those witnesses. You, of course, are represented by public defender Aaron Robinson. She would be present at trial to cross-examine any witnesses and contest any charges brought against you. You'd have the right to have the court order any witnesses appear in your defense. You have the right to remain silent during the trial. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim that the plea was a result of any promises other than the stated agreement on the record or threats that it was not your choice to plead guilty. You'd also give up the right to appeal any rights from trial. Since you're not having a trial today, you're going to be pleading guilty. It's my understanding.
Right.
Is it your intent to waive those rights and plead guilty today, sir?
Yes, sir, it is.
Yeah, I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right, I'm going to bring your attention back to December 6th, 2022 at the offense location of Lowe's in the city of Lansing. Were you at Lowe's which was a store open to the public in the city of Lansing on December 6th, 2022?
Yes, sir.
And did you take items for sale from Lowe's that were under $200 on that date?
Yes, sir, I did.
And you did so without paying for it, is that correct?
Yes, sir.
All right. Any question concerning the factual basis, Mr. Bradowitz?
Nothing from the people.
Ms. Robinson?
No, Your Honor.
I find the factual basis to be understanding, voluntarily, and accurately made. And I would set this for sentence so that you can refer the restitution to him.
Yes, Your Honor.
So
Actually, we could, I mean, Your Honor, if you wouldn't be opposed to it, we could just sentence him today and then just set it out for
a restitution
for a
hearing.
restitution hearing. That way he's earning
Works for
credit.
me.
Yeah.
So what we're gonna do, Mr. Ross, is there's no objection to immediate sentencing today?
No.
All right. So without objection to immediate sentencing today, and then we'll set the restitution to be set by hearing. So I won't order any restitution until we get a number for you. All right, sir?
Yes, sir. Thank you.
All right. So the sentencing of the court is to follow the agreement and indicate that the defendant is to spend 30 days in the Ingham County Jail. There is I'm going to waive fines and costs at this time. There is a crime victims' rights fee of $75 and a court cost fee of $50 for a grand total of $125. And then there's restitution to be determined. So we will set that aspect of it. No probation's ordered. So we will set any fines and any crime victim rights for $50. Let's see what the restitution is, and I'll do that all on one date, so we have a good number. Because it doesn't make sense to do it now if we don't have a number set for restitution.
That's fine.
So restitution hearing would be set for
July 25th at 1:30.
July 25th at 1:30. All right, so Mr. Ross, we're all done with sentencing. I'm holding off on the crime victims' rights and $50, ordering that until I see what the restitution number, and we'll be all back here July 25th at 1:30 in order to make a determination of the number. If there's a number that the prosecutor gets beforehand, is able to provide it to the defense attorney and it's agreed upon, then we may not need that hearing. But for right now, it's set for July 25th at 1:30. Okay, sir?
Yes, sir. Thank you.
All right. Anything else for the record? Docket 2300959, Mr. Brodowitz.
Nothing from the people.
Ms. Robinson?
No, Your Honor, thank you.
All right, Mr. Ross, you're all set. And did you want to go on RB
Yes, I believe we're ready.
Do you want to tell her that case has been adjourned? The date, and she's a little late, but her client was here. I can put it on the record, but if you want to, there's no reason to.
I'll send her a chat.
Okay. All right. Six, 9. 4, 3, 2, and 4. All right. All right, we're on the record in dockets 2301, 441, 442, 443, and 444. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Michael Anderson on behalf of Ms. Arvizu, who does appear via Zoom.
All right. And ma'am, you are Christine Arvizu?
Yes, Your Honor.
All right, thank you. This is the time set for a pretrial in the matter. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor, at this time, the people did make an initial offer for the defendant to plead to one of the counts of a dog malicious destruction of property, at which time the people would seek to dismiss the other 3. However, after conversations with defense counsel, I believe we're going to ask for an adjournment for a second pretrial for negotiations to continue, Your Honor.
And is that your understanding, Mr. Anderson?
It is, Judge.
All right. And do you know, I think we're probably looking out a little bit on this just to get, because our schedule is getting backed up. So it's probably looking at a July 18th date. How's that look? July 25th. Does that work for your schedule, Mr. Anderson?
It does, Your Honor.
So we'll reset these 4 files for July 25th at 9 a.m. You have that date, Mr. Brodowitz?
Yes, Your Honor.
All right. Anything else for the record on any of these files will all be reset for July 25th at 9 a.m. on dockets 2301, 441, 442, 443, or 444. Mr. Brodowitz.
Just briefly, Your Honor, there was an offer with a part of that offer was restitution as well. Just so it's on the record.
All right. So I know an offer's been made and restitution is a part of the offer, but we've reset it for negotiation purposes for that July 25th date. Mr. Anderson, anything else for the record on any of those files?
No, Your Honor. Thank
All
you.
right. You're all set today. Thank you.
Thank you.
Mr. Arvizo, we reset it from July 25th at 9 a.m. Please keep in contact with your attorney, Mr. Anderson, okay?
Okay, thank you.
Thank you.
Yep, go on there. I'll scan you real quick, bud. Have a seat in front of you.
Ms. Wanji, are you there?
I am, Your Honor.
Ms. Wanji, we were here with Ms. White. It was set for 9 o'clock, so we called that case probably 15 minutes ago. What we did, all we did was adjourn that matter so that I know your conflict counsel, so you could get involved in it. So we adjourned the matter, and I'll give you the adjournment date. It was adjourned to July 18th at 9 a.m.
Okay, Your Honor. Sorry, I thought
All
I
right.
had that 10 o'clock. Sorry about that.
But we didn't know if the conflict counsel paperwork had gone all the way through yet.
It
So
hasn't.
we weren't sure. Yeah, we weren't sure. But it's so you can get a hold. Ms. White is adjourned to July 18th. All right.
Okay, thank you, Your Honor.
All right. Thank you. You're all set.
Thanks. What
And then
time?
we'll go
Sorry.
on Mr. You're good. Mr. Ferrier.
Yes, Your Honor.
Oh, what time at 10?
9.
At 9 o'clock.
I give up.
I missed her on that. Mr. Ferrier. So we're on the record in docket 23-01373. That's people of the state of Michigan versus Justin Ferrier or Ferrier. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Casey Schaefer on behalf of Mr. Ferrier, Public Defender's Office.
All right. And sir, you are Justin Ferrier?
Barrier, yes, Your Honor.
Ferrier, okay. This is the time set for a pretrial in the matter. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor. At this time, the people have received in the victim witness statement, a notice that the victim in this matter was recanting their statement and said that no assault had happened. And so with that information, Your Honor, the people would seek to dismiss this case. or because the people would be unable to meet their burden at this time.
People move to dismiss based on unable to meet burden and CB statement, right?
Yes.
And any comment from the public defender's office, Ms. Schaefer?
No, Your Honor.
All right. With that understanding, Mr. Ferrier, the people have moved to dismiss without prejudice, which means they could reissue if they choose to, but for our purposes today, the case is dismissed. Do you understand that, sir?
Yes, Your Honor. Thank you.
All right. So you should be all set. Thank you for your appearance today.
Thank you.
And I'll sign the nollie to that effect.
Thank you, Your Honor.
And that's all for the record, docket 23-01373. Thank you for your appearance today.
Ms.
Thank you.
Schaefer? Your bar number, please?
She's an intern.
She's an intern. She's practicing under mine. Thank you. You're welcome.
All right, so Mr. Ferrier is all set. All right, so we're on the record in docket 23-01505. That's people of the state of Michigan versus Stephen W. Lunsford. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Taylor Wicks, Assistant Public Defender on behalf of Mr. Lunsford.
And sir, you are Stephen Lunsford?
Yes, sir.
All right, this is the time set for a pretrial on the matter. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor. At this time, the people have made an offer for the defendant to plead to an added count 2 of trespass with a Killebrew agreement for fines and costs. However, I believe this is going to be left on for a final pretrial.
All right, Ms. Wicks?
That is correct.
Okay. So we're going to set for final pretrial June 27th at 8:30.
Do you want adjourned?
Did you want a corresponding jury trial date or just a final pretrial date?
Just the final pretrial at this time right now. Thank you.
So June 27th at 8:30 is set for final pretrial. That's live in person. Anything else for the record in docket 23-01505, Mr. Brodowitz?
Nothing from the people, Your
Ms.
Honor.
Wicks?
Nothing from defense.
All right, Mr. Lunsford, please keep in contact with your attorney, either Aaron Robinson, Lauren Sutter, or Ms. Wicks, depending. But you're set for June 27th at 8:30, okay, sir?
All right, no problem, sir.
All right,
Thank you. The honey bee Garson, did you?
Oh, yeah, I did. Thanks.
All right, thank you. You're great, sir.
You too.
Wow.
Did you want to meet with Mr. Thomas?
Yes.
And we also have somebody who's in the. So, Mr. Alvarado, we're going to place you in a breakout room with your public defender, Ms. Wicks, okay?
Okay.
And Mr. Thomas, I'm going to place you in a breakout room with the assistant prosecuting attorney on the case, all right?
Yes, sir.
Thank you. All right, Mr. Thomas, we'll call your case. So we're on the record in docket 22-02589. That's the People's State of Michigan versus Kenneth Thomas. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
And sir, you are Kenneth Thomas?
Yes, sir, Your Honor.
All right, thank you. Mr. Brodowitz, this is the time set for a pretrial on the matter. How are we proceeding?
Yes, Your Honor. At this time, Mr. Thomas has shown me that he has a valid dog license for the dog in question. That would be Psycho. I believe it was misspelled in the police report, however.
Okay.
So at this time, the people would be seeking to dismiss the ticket.
And that's your understanding, Mr. Thomas? The people are moving to dismiss the ticket based on compliance?
Yes, sir, Your Honor. Yes.
All right, and it was on a complaint.
Oh,
So we'll print out the nollie.
Okay.
All right, so we'll print out the nollie. People are going to move to dismiss without prejudice for compliance purposes. Without prejudice means they could reissue. Most likely they're not going to, but they could reissue if they choose to. But for our purposes, the case is dismissed, and I will sign a nollie process to that effect.
Thank you, Your Honor.
And we'll let Mr. Brodowitz sign it first. So here's the nollie right here. If you sign that, then I'll sign it. We'll all be signed. Thank you. All right, for the record, I'm signing the nollie pros concerning the dismissal of these cases. And Mr. Thomas, you should be all set. Thank you for your appearance today.
All right, and I'd like to thank the court as well. Thank you all.
Did you ask a question? I couldn't hear him.
so you wanted to thank the court.
Oh, thank you, sir. Have a nice day.
Yeah.
Yeah. So, Ms. Wright, we will do the FTAs.
Sure.
All right. So we're on the record in docket 23-01137. That's people of the state of Michigan versus Sonia Villanueva. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Karen Robinson, Assistant Public Defender for Ms. Villanueva.
All right, this is the time set for a pretrial in the matter. We previously adjourned this on May 16th. It would appear that it was scheduled for 9 o'clock, 8:30, scheduled for 8:30. It is now 9:57. It appeared that the defendant failed to appear. Mr. Brodowitz, how would you like to proceed?
At this time, Your Honor, the people would ask that a bench warrant be issued and any bond be forfeited.
Ms. Robinson, I'm assuming you'd like a 48-hour hold on that?
Yes, please.
Okay. So if the defendants fail to appear, bench warrant bond forfeiture. I have no previous failed to appears, so I'll do so with a 48-hour hold. That's all for the record, 23-01137. Then we're on the record in docket 23-0431 and 32. That's people of the state of Michigan versus William Curtis Hill. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Taylor Wicks, Assistant Public Defender, filling in for Lauren Sutter on behalf of Mr. Hill.
And this is a time set for a pretrial in the matter. This was scheduled for 9 o'clock. It is now 9:58. I do not see Mr. Hill in the Zoom courtroom or in the actual physical courtroom. It would appear that the defendants failed to appear today. Mr. Brodowitz, how would you like to proceed?
At this time, Your Honor, as the defendant has failed to appear, the people would ask that a bench warrant be issued and any bond be forfeited.
Your Honor, I would ask for a 48 hold as these are non-assaultive cases.
And based on the, I don't have any previous fail to appears, so I'll place a 48-hour hold. on both bench warrants and bond forfeitures. All right. Anything else on dockets 23-01431 or 32, Mr. Brodowitz?
Nothing from the people, Your
Ms.
Honor.
Wicks?
Nothing from defense.
All right, you should be all set on that one. And we have Mr. Alvarado, is that correct?
Correct.
All right. So we're on the record in docket 23-01692. That's people of the state of Michigan versus Jesus Joseph Alvarado. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Taylor Wicks, Assistant Public Defender, filling in for Lauren Sutter on behalf of Mr. Alvarado.
And sir, you are Jesus Joseph Alvarado?
Yes, sir.
All right. This is the time set for a pre-trial in the matter. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor, at this time, the people have made an offer for the defendant to plead to an added count 2 of disorderly person jostling. And with that, we would dismiss count 1. And I would leave it then to the defense to.
Ms. Wicks?
Your Honor, at this time, defense would be requesting a final pretrial in this matter.
Final pre-trial will be on?
June 27th at 8:30.
I don't think so. No. So we'll do a final pretrial on June 27th at 8:30. That'll be a live pretrial. Mr. Brodowitz.
Nothing else.
I thought you were going to say something.
No.
That was me, Your Honor. I was going to let Wendy know that I would take the jury trial date in this one if she did.
All right. If she's got a jury trial date, let's get it for the.
Sorry. July 18th at 8, please.
Okay, July 18th at 8 o'clock. Thank you. All right, so we set it for final pretrial, which would be a live pretrial, live in person on June 27th at 8:30. Jury trial set on July 18th at 8 a.m. Anything else on the record docket 23-0162692, Mr. Brodowitz?
Nothing from the people.
Ms. Wicks?
Nothing from defense. Thank you.
All right, Mr. Alvarado, please keep in contact with your attorney, Ms. Sutter or Ms. Wicks, and we'll see you on June 27th at 8:30. Okay, sir?
Okay, sir.
All right, you're all set. Thank you for your appearance today. or personal experience that might influence you for or against the prosecution, the defendant, or any witnesses. One or more of these things could cause you to be excused in this case, even though you may otherwise be qualified as a juror. The questions may probe deeply into your attitudes, beliefs, and experiences. They are not meant to be an unreasonable prying into your private life. The law requires that we get this information so that an impartial jury can be chosen. If you do not hear or understand a question, you should say so. If you do understand it, you should answer it truthfully and completely. Please do not hesitate to speak freely about anything you believe we should know. During jury selection, you may be excused for serving on the jury in one of two ways. First, I may excuse you for cause. That is, I may decide that there's a valid reason why you cannot or should not serve in this case. Or a lawyer from one side or the other may excuse you without giving any reason for doing so. This is called a preemptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you are excused, you should not feel bad or take it personally. As I explained before, there simply may be something that causes you to be excused from this case. I will now ask you to stand and swear to answer truthfully, honestly, and all the questions that you will be asked about your qualifications to serve as a juror in this case. If you have religious beliefs against taking an oath, you may affirm that you will answer all the questions truthfully, fully, and honestly. So please stand. Do you solemnly swear or affirm that you will truthfully and completely answer all questions about your qualifications to serve as jurors in this case? You can say, I do.
I do.
All right, thank you. You may be seated. I'd like to introduce you to members of my staff. Wendy Holden is my court recorder. Nathaniel Neves is my court officer. This is a criminal case involving the accusation or charge of commonly known as assault and or assault and battery, which I will explain more fully. This charge has been made against the defendant, who is Melvin Eugene Cornell. The defendant's lawyer is Ms. Erin Robinson. Ms. Robinson, please introduce yourself and your client.
Hi, everyone. My name is Erin Robinson. I have the pleasure of representing Mr. Cornell here today.
The lawyer for the state of Michigan is Assistant Prosecuting Attorney Jeffrey Brodowitz. Please introduce yourself and list any witnesses you anticipate calling in this trial.
Hi, everyone. My name is Jeff Brodowitz. I'm the Assistant Prosecuting Attorney on this case. The witnesses that I plan on calling today are Miss Teresa Hayhoe, now Miss Teresa Spencer, and Mr. Gregory Beechin.
All right. The prosecutor witnesses indicated are Teresa Spencer. She's on the complaint as under her previous name, Teresa Hayhoe. So I placed that in parentheses. And Gregory Beechin. Okay. And then we have one defense witness at this time. Krista Dodson is an anticipated witness. Does anyone in the jury box or waiting to be chosen know the defendant or any of the lawyers or witnesses?
No.
Thank you. We think this trial will last for 1 day. If you believe the length of the trial will be a real hardship for you, please let me know right now. Is 1 day and a hardship for anybody?
No.
Some of you may have health problems that would prevent you from serving on a jury. For example, does anyone have a medical problem that makes you unable to sit for 2 or 3 hours at a time? Does anybody have a medical problem that would not allow you to sit 2 or 3 hours at a time?
No.
Does anyone have a sight or hearing problem? If you do so, we can make
I
accommodations.
did hear a yes in the last question from behind the
Okay.
side.
So is that sight or hearing, or is that a inability to sit?
It's by sight of hearing.
Okay.
I had it in here hard of hearing, but since I was born.
All right. And would sitting closer to the witness help?
Pardon?
Would sitting closer to the witness help? You don't know? Okay. All right, sir.
I just have a neck issue. Sometimes my sitting becomes a very painful thing.
All right. I would share that with the attorneys if you get called up, okay? And we'll keep an eye on both of you just to see. All right. All right. So this is the reading of the information. This is a criminal case. The paper used to charge the defendant with a criminal case is called an information. The information in this case charges the defendant Melvin Eugene Cornell with a crime of assault and or assault and battery and reads as follows. On or about December 14th, 2022, at the offense location of 2900 Collins Road, City of Lansing, Ingham County, State of Michigan, the defendant Melvin Eugene Cornell did make an assault or an assault and battery upon the following person, Teresa Hayhoe. This defendant has pled not guilty to the charge. You should clearly understand that the complaint I've read is not evidence. A complaint is read in every criminal trial so the defendant and jury can hear the charges. You must not think it is evidence of his guilt or that he must be guilty because he has been charged. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or do anything. If you find that the prosecution has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of the case. The clerk will now draw your names, and I actually have the list, so I will draw your name. As your name is called, please come forward and take your seat in the jury box, starting in the back row with the seat closest to the back of the courtroom and filling across the back row and then the front row in the same manner. So what I'll do is the first name I call will go to the first seat, which essentially means you have the longest to walk because you have to go all the way and then front, and then we'll go from there. We're going to call 7 names to start, okay? So the court will call from a selection that's already that's been randomly selected, a Sage Aaron Ritter. All right, Miss Aaron Ritter, I'll have you take the first seat all the way through. So you have to go all, yep. A little maze here all the way to the front. Sherry Ann Trujillo. Kirsty Caprice Rice. Louis Serna. Stephen Morrison. William Brian Bitzer. And Devon Strunk. Let's see it, Devon Renee Strunk.
She's not here.
Okay. Mary Esther Faber. Thank you. Ms. Faber, you get the 7th seat right now. All right, the lawyers are going to ask you some questions in voir dire right now. Just to ask you some general questions. Mr. Brodowitz, would you like to proceed?
Yes, Your Honor. Thank you. Good morning, everyone. Good morning. Thank you for being here. So like the judge said, myself and Ms. Robinson are going to ask you some questions. We're not trying to pry into your personal lives or embarrass you in any way. We're just, looking for some information to try and get, the most open-minded fair jury possible. So to start with, I guess, has anyone ever served on a jury before? Mr. Morris?
Yes.
Was it criminal or civil jury?
It was a drunk driving case.
Okay, so criminal. And were you able to come to an agreement or a verdict in that case? Yes. And what was the verdict?
It was knocked down to a driving while intoxicated.
Okay, but it was a guilty to a lesser charge? Yes. Okay. Anyone else served on the jury before? So I know the judge kind of already asked it, but I guess I'll just ask again. Does anyone know anyone, the defense attorney, the defendant, anyone from the prosecutor's office?
No.
Has anyone ever had contact with the prosecutor's office before as a witness, victim, or defendant of any sort?
No.
I was a victim about 30 years ago.
What type of crime was that, sir?
I was robbed.
Okay.
At gunpoint.
Okay. And is there anything, I know it was a while ago, but is there anything about that contact that would make you feel strongly one way or the other towards either side?
No, a long time ago.
Okay. Does anyone have any friends or family, I guess that are in the medical field?
My niece is a nurse.
Okay. And so I'll just say in this case, this happened at, this is alleged to have, I guess, happened at McLaren Hospital, and the victim is a nurse there. Would that have any impact on your fairness and impartiality here in this case? Okay. And so just a couple more brief open-ended questions. Is everyone here going to give the same weight, credibility, and weight, or I should say just weight and credibility to the witness that is out there on the stand?
Yeah.
Okay. So as the judge read off of the information, the defendant has been charged with the crime of assault and battery. Everyone here has heard of assault and battery?
Yes.
Okay. Has anyone here ever had a family member, close friend, anybody who's been the victim of assault and battery?
No.
Okay. See. So the assault and battery has several elements to it. One, and that I will need to prove, as the judge said, beyond a reasonable doubt. First is that there was a harmful or offensive touching, that touching was non-accidental, and that the touching was against the person's will. Okay. Does anyone have, I guess, an issue with those elements? Does anyone think assault and battery should be something else?
No.
Okay. Now, can everybody agree that in this case here, the victim is not on trial, and that their way that they would have responded to this situation, that you're not here to pass judgment on that at all?
Objection, Judge. I think he's asking about credibility and how they can determine credibility, but that's not the proper statement of law and how that's determined.
Ms. Radowitz.
No, I'm just simply asking that the victim they can take credibility however they want, Judge, just that how the victim responds not be held against them.
But you're the trier of fact, so you can take the witness's testimony and you can use it in any way that fits your personal experience and your framework. But if you expect every witness to act the same way, you understand that not every witness acts the same way. All right, you may proceed, Mr. Radowitz.
So another element that people typically look at, or in cases like this, are injuries. So under the law, injury is not an element of assault and battery. Is everyone okay with that?
Yeah.
Okay. And now if there are no visible injuries or long-lasting injuries, would anybody be unable to convict because of that? No. So another element that might possibly arise in this case is the element of drinking and alcohol. Does anyone have any sort of religious or moral beliefs that would make it difficult for them to be fair and impartial in this matter?
No.
Okay. And does anyone here think that if in this case the defendant were under the influence of alcohol or some other substance, that would be an excuse for insult?
Objection, Judge. This is pre-trying the case right here.
Response?
Your Honor, I'm simply trying to find the most fair and impartial jury possible. There's been no evidence presented. I'm just stating that that's a possibility that could come up, and I want to make sure we have a fair and impartial jury.
All right, I'm gonna overrule the objection. I think you can indicate that. I think you can ask the question whether the alcohol influence is going to influence their decision or not. They've already answered that question in one regard. Since alcohol obviously is a factor, I think you can ask the question.
So does anyone have, would anyone think that would be a reason to not convict?
No.
Okay. Now, as for another element, like I said, that I have to prove is intent. And so does everyone recognize that intent can be determined by the defendant's actions or words? Yes. Okay. And do you believe, as the trier of fact, that you could determine intent from the testimony that's presented here and the evidence that's presented here today. Okay. And does everyone here understand the difference between an intentional act and an accident?
Yes.
Okay, and you can tell the difference?
Yes.
Okay. So most of the evidence you're going to hear today is going to be witness testimony. And so is anyone expecting some sort of, independent eyewitness with a perfect memory to come forward and say exactly what happened? Okay. Is anyone expecting some sort of, high-tech scientific gizmos or whatever like you see on TV? Okay. And does everyone understand and agree that people have differing emotions and motives and imperfect memories?
Yes.
Okay. And that, as already stated, it will be up to you as the jury to determine credibility and believability and use that in your decision making?
Yeah. Yes.
Okay. And so, as the judge also stated, I have to prove this case beyond a reasonable doubt. As we all know, the defendant is presumed innocent until proven guilty, and that the people have that burden of proof. So I will ask Ms. Arend Ritter, what does beyond a reasonable doubt mean?
No questions, like you don't question it at all. You can believe that.
Okay, so would you say that's, I guess, would you say that's like 100%, or can it be?
Yeah.
Okay. And how about you, Ms. Faber? How would you define reasonable, beyond a reasonable doubt?
Without questioning the decision.
Okay.
Again, 100%.
And Ms. Reese, how would you describe beyond a reasonable doubt?
That you're not questioning.
Okay. And so if I'm able to prove my case beyond a reasonable doubt here, does anyone think of any reason, or would anyone have any issue not rendering a guilty verdict? Okay. Now, one aspect of any criminal case is punishment. Now, I want, the punishment is solely determined by the judge in these matters. And so would anyone take, and punishment should not then come into your decisions as jurors, just simply what, the facts are in this case. Does anyone have an issue not taking punishment into effect in your, consideration in your deliberations?
No.
No further questions at this time.
Questions, Ms. Robinson?
Yes, Your Honor. Good afternoon, everyone. And although I'm asking the questions to you guys, listen in because you guys might be coming up here and sitting up here as well. Does anybody here remember my name? There we go. Okay, good. Yeah, we got some good memories over here. How about my client's name? Yeah, his name's Mr. Cornell, right? And today is the most important day of his life. He's facing a criminal charge. He's here, he's sitting here, and he's been arrested. And now it's time to pick a jury for him to go to trial on a case. So I'm going to ask that you guys be open and honest. We might talk about some things that could be sensitive materials. We're just here to get to, see what everybody's true beliefs are. My greatest fear is that I'm asking questions and I don't get truthful answers. So if we can just all be open and honest with each other, that's really the only thing that I ask for when talking about these issues and these cases. And it's okay. There's no right or wrong answers. No one's judging you. But I wanted to start off and ask, does anybody here think that because Mr. Cornell is sitting here today, right? He's been charged with a crime. He's been charged with assault and battery. He's been arrested. He's gone through all the previous stages, right, that a court case goes through. And he's here today awaiting trial, going to trial. Anybody here thinks that because, oh, well, he's gone through all of these steps, right? He must have done something.
No.
No? Okay, and let's see, and if I mess up your guys' names, please correct me. Ms. Erin Ritter, right?
Yep.
Okay, great. You said no right away. Why is that?
Because I watch a lot of TV and read a lot of books, and I know that things aren't always what they appear to be from the beginning.
Okay, yeah. And Ms. Faber, I heard from you, you said no as well. Tell me more about that.
The process exists for this very reason,
Okay,
or we wouldn't need a process.
yeah,
We can't make assumptions.
okay. Yeah, we don't really judge a book by its cover, right? Yeah, I know that I've been in situations before where I feel like I've been judged based on how I look, or, you know, something right off the bat. I know probably we've all been to high school, right? We've all been judged for those kind of things. That happens. But this process exists, right? So we don't do that. We don't judge a book by its cover. And as you see, nobody's hiding it. Mr. Cornell sitting here. He's got a face tattoo. He's got hand tattoos, right? Do you think because he's got that, he must be guilty of something? He must have done something like?
No.
No? Okay. Mr. Is it Bitzer?
Yeah.
Okay. What do you think about that?
Verbal.
Okay. Yeah. So even though he's got these tattoos, you know, he might look a little rough around the edges. Are you gonna hold that against him?
I have no issue with that.
Okay. Does anybody here have an issue with that?
No.
Now, we kind of talked a little bit about this, but the case is going to go into have some discussion about drinking alcohol and perhaps substance abuse. Has anybody ever dealt with substance abuse issues either within their family, friends? Yes, Ms. Faber, can you tell me about that if you feel comfortable?
A sibling,
Okay,
and it's been a really powerful experience,
okay,
both negative and positive.
all right,
With our family.
okay. Well, I'm sorry that that's happened to your family. I know that it affects a lot of people. Did anybody
It's
else?
Nothing to be sorry about.
Thanks. Ms. Trujillo, right?
Yeah.
Great.
My niece. She was killed by a gun.
Oh, I'm so sorry. Hearing that, I can just hear, you know, the effect it has on you right now, and I'm really sorry. Do you need a tissue? Okay, well,
Thank you.
yeah, they're right there if you need it.
I know,
Okay.
it's been like 20 years.
For sure. And I'm very sorry that that's happened to you. Knowing that this case involves possibly some discussions about substance abuse, about alcoholism, is that going to affect your ability to be fair and impartial here? Is that what happened to your niece?
It's not a driving issue, so I don't.
You don't think so? So even if somebody is talking about how, you know, how alcoholism has affected them or done things like that, you don't think that that's going to bring up any memories or anything like that?
No, I've had extended family that was, you know, alcohol themselves, so.
Okay.
I could take care.
Okay. Thank you for being open and honest with me. I really appreciate that, Mr. Hugh. And is it Ms. Rice? Did I see you not as well? Did you have somebody? Okay.
Yeah.
Can you tell me about it?
A sibling.
Okay.
And multiple family members.
Okay, so that's someone pretty close to you, right? How did that affect you?
I mean, I tried to.
Okay. Was it a difficult struggle at times?
Yes.
Okay. Anybody that's gone through that, do you think that's going to affect your ability to kind of see the evidence? Is it going to cloud your judgment today? No. Let's see. Mr. Cerna, I haven't heard from you yet. Have you ever had somebody that's been affected by substance abuse?
No.
No? Okay. Now, We already talked about a little bit about people who work in healthcare. I know that none of you on your questionnaires answered that you guys work in healthcare. Anybody close to someone that works in healthcare, spouse, family member? Yeah, Mr. Morrison, yeah. Okay, can you,
My fiance works in.
okay, what does your fiance do?
For the doctor's office, she's a medical assistant.
Oh, okay. Knowing that this case, the alleged victim in this case works in the medical field, do you think that's gonna impact your ability? Now, we also kind of talked a little bit earlier about credibility of witnesses and what to kind of look for when somebody is on the stand testifying, right? So there's different ways to determine credibility, and the law is going to give you some instructions on how to do that. But what are some things that you would look for in determining maybe whether a witness is telling the truth or not? Anybody give me some examples and put me on the hot seat?
Keeping eye contact.
Keep an eye contact. That's a good one. Anybody else?
Consistency in what they're saying.
Okay, consistency. What about body language? Yeah, big deal. Okay. All right, yeah, those are all definitely really good things. Anybody here know what the number one fear in America is off the top of their head?
The number one.
Fear in America is? I'll tell you, it's public speaking. Okay? Yeah, so many Americans do not like to speak in public, right? I luckily do not have fear, kind of why I'm doing what I'm doing. But there's a lot of us out there that don't like to speak in public, and maybe even this experience and answering questions is not, you know, your favorite thing in the world to do on a Tuesday afternoon. We also kind of talked about how the state has the burden of proof in this case, and they have to prove beyond and to the exclusion of a reasonable doubt, right, that Mr. Cornell committed this offense. Now, he has the right to either testify or not testify, right? What are some reasons that an innocent person might not testify? We already know public speaking, being scared to speak in public, right? Anybody have any other reasons why maybe an innocent person may choose to be like, oh, I don't want to take the stand?
Not enough evidence to convict him.
Yeah, the state hasn't proven their case, right? That's a really good one. Anybody else in favor?
Fear of what the prosecution might ask.
Yeah.
Maybe beyond the scope of the trial or the
Okay.
charges.
Right, sure. Being up there, having a bunch of questions thrown at you in the heat of the moment, that can be stressful. Yeah, anybody else? Would anybody here have to hear from Mr. Cornell in order to reach a verdict? No? Did I all hear no's? Mr. Bitzer, if you didn't hear from Mr. Cornell, do you think that would affect your judgment?
No.
No, okay. All right, what if I told you guys, just walk in here today, right? I tell you guys I won the lotto. Which one of you guys believe me? Mr. Morrison's looking like me, like I am lying out of my teeth. Miss Faber, you raised your hand. Do you believe me?
Sure.
Okay. All right. Well, good for you. I've never had anybody answer that question that they would believe me before. All right. But you guys seem to be a little bit more hesitant to say that you believe me, unlike Ms. Faber over here. So what if I said, well, I did win the lotto, right? And Mr. Neves over here, he saw the ticket this morning. Who here believes me now? Maybe you're kind of leaning like it a little bit.
Evidence there, or possible.
Possible. Okay. All right, Ms. Let's see, Erin Ritter. Would you believe me? Yes or no?
Well, my brain first went to, did you win the Mega Millions or did you just win like $2?
Okay.
So I would have a question. How much did you win?
Let's say it's $1 million.
Less likely, but possible.
Possible.
So
Okay.
yeah, if he co-signed and said he saw the ticket, then I'd be like, okay, you're either both lying to me or.
Okay.
Sure.
All right, Mr. Morrison, what would you want to see from me in order for me, for you to tell me that or for me to show you that I won the lotto?
I wanted the ticket.
You want the ticket? What about you, Mr. Cerna?
Same thing, the ticket.
Okay. And Ms. Rice?
Yeah, the proof.
You want the proof, right? Proof's in the pudding, right? You got to see that ticket. You want to see it. All right. Well, I am done asking you guys questions for now. Might get up here and ask a few more questions depending on how this goes. But if you are selected for the jury, I just ask that you guys keep an open ear, listen to everything that comes your way, and make a fair judgment in this case. Thanks for your time.
Challenges for cause from the people.
Nothing for cause, Your Honor.
Challenges for cause from the defense, Ms. Robinson. And please take some time if you need it. I know you just got done asking questions.
No challenges for cause at this time, Your Honor.
All
Thank
right.
you.
Preemptory challenges from the people.
Just 1 second, Your Honor. This time, the people would like to thank and excuse juror number 6.
Juror number 6 is thanked and excused. So that's Mr. Bitzer. Mr. Bitzer, you're all set. Thank you for your appearance today. And you can go with Ms. Kneeling and she'll make sure that you're taken care of.
Yes, sir. Thank you.
We'll replace juror number 6 with Amanda Moser. All right. Ms. Moser, if you'll go right to juror number 6's chair and have a seat. Ms. Moser, you had the opportunity to hear all the questions that were asked to the juror. Is that correct? Is there anything that you'd like either lawyer to hear based on the questions that you heard?
No.
All right. Mr. Brodowitz, any questions, any follow-up questions?
Just briefly. Ms. Moser, I know the judge kind of, but just more specifically, any sort of interactions with the prosecutor's office or the public defender's office or defense attorneys that would make you think one way or the other, make you more likely to decide with one side over the other? Okay, and then if you could just speak up a little bit, they're recording everything. The other thing was any close friends or family members or anybody who's in healthcare at all? No other questions at this time.
Ms. Robinson, any follow-up questions of the new juror?
Yes, just briefly. Afternoon, Ms. Moser, how are you? Good. Any of the questions that I asked in particular stick out with you? Okay. Anybody in your family affected by or close friends maybe affected by substance abuse issues, alcoholism? No? Okay. Anything here in this case that would make it hard for you to serve as a juror or be like fair and impartial? Okay. I see on here that it says that you are a content creator on social media. Is that right? Sort of. Okay. Can you tell me a little bit more of what you do? A lavender farm. Okay, cool. Anything, knowing that, like, seeing Mr. Cornell sitting here today, do you think he's just guilty because he's sitting here today? He's got tattoos. Might look a little rough around the edges. Okay, all right. Well, thank you for answering my questions, Ms. Moser.
Preemptory challenges, Mr. Robinson.
One moment, Your Honor. The defense would like to thank and excuse juror number 2.
Juror number 2, Ms. Trujillo. You should be all set. And you can meet with Ms. Kneeling and she will take care of you.
Okay. Yeah.
Thank you. Thank you for your appearance today, ma'am.
You're welcome.
And we'll replace juror number 2 with a Jaden Williams. Mr. Williams, I'm going to have you step past everybody to juror number 2's spot. Thank you. Now, Mr. Williams, you had the opportunity to hear all the questions that were asked of your fellow jurors.
Yes.
Okay, and do you have anything you think any lawyer should, Mr. Brodowitz or Ms. Robinson should hear based on those questions?
Among the lines of substance abuse, my dad was an alcoholic pretty much my whole life.
Okay, and would the fact that you've had experience with alcohol as a substance through your relationships, would that affect your ability to sit as an objective trier in this case?
Not really. I don't have an issue with alcohol, but as far as alcoholic, not trying to be rude, nothing against him. I sort of have issues with alcoholics growing up. My dad grew up.
All right. That's just part of your framework, but you'd be able to set that aside and listen to testimony.
I can still
Listen to testimony, and then make a credibility argument based on what you see.
Yes.
All right. So you wouldn't prejudge anybody if they went up there.
No.
All right. Mr. Brodowitz, any questions concerning any follow-up questions?
Yeah, just briefly, Your Honor. Mr. Williams, any any experience, I guess, with the prosecutor's office, with the public defender's office, or defense attorneys of any sort?
Not that I know.
Okay, and so nothing that would make you biased or impartial to one side or the other?
No.
All right, and then any friends or family or anybody who works in the medical field?
No.
Okay. And then again, just briefly, it's listed on here that you're a Packers associate. Can you tell us a little about that?
Works in a warehouse for GoPuff. It's a delivery service.
Okay. No other questions at this time, Your Honor.
Ms. Robinson, any follow-up questions of the new juror?
No questions.
So we are back to challenges for cause from the people.
One second. Nothing for cause, Your Honor.
All right. The challenges for cause from the defense?
No, Your Honor, thank
All right,
you.
thank you. Preemptory challenges, Mr. Brodowitz.
Yes, at this time, the people would like to thank and excuse juror number 7.
Okay, Ms. Faber, I would thank you for your attendance today, and you can meet with Ms. Kneeling.
Thank you.
And Ms. Faber will be replaced. That's the number 7 with please correct my pronunciation, Harris Zavarovic.
Here is Jay Fruvis, sir.
Okay, thank you. All right, if you take the first seat. And Mr. Brodowitz, you heard the questions that were asked of your fellow jurors, sir?
Yes, sir.
All right. Any questions or anything you think either side should hear concerning the questions that you're familiar with?
Not at this time.
All right. Mr. Brodowitz, you may proceed.
Just briefly. Any, is it Zafarovich?
Jafrovich.
Jafrovich, okay. Mr. Jafrovich, any experiences with prosecutor's office, defense office, anything that would make you impartial to one side or the other?
Nope.
Any friends or family members who are in the medical field?
My partner works as a phlebotomist.
Okay, and would that sway you to one side or the other,
Not
make you
particularly.
impartial? Okay. No other questions, Your Honor.
Ms. Robinson, any follow-up questions?
Just briefly.
All right.
I'm going to call you Harris because I'm going to slaughter your last name, okay? So, Harris, any other questions that I asked that stuck with you one way or the other?
Nope.
Okay. What about anybody in your family, friends, substance abuse issues, alcoholism? No? Okay. Knowing that this case has gotten this far, it's gone from arrest, pre-stages, we're here today, we're about to go to trial. Mr. Cornell sitting here today. Do you think he must have done something to get here?
Well, like Ms. Faber said, there is a process, so there's a reason it's gotten to this point.
Okay, and what do you think about that process?
Could you specify the question?
Yeah, I guess I'm just trying to get your feelings on the criminal justice process in general. Like, how do you feel about it?
I mean, it's gotten us this far, right? So
Okay, yeah. So do you think that, well, I guess knowing everything that we've kind of talked about so far, there's nothing here that would make you not be able to be fair and impartial then?
not particularly, no.
Okay, anything maybe?
I was in college for EMS a couple of years ago, and I'm going back this fall. So I've had a handful of clinical experiences.
Yeah,
So seeing some of those police interactions and whatnot may or may not disqualify me. But since I don't work in the medical field, I answered no on the questionnaire.
okay. Well, when you say disqualify you, why would you think they would disqualify you? And I'm not trying to put you on the hot seat.
Nothing in particular, just by the lawyer's opinions.
Okay.
Yeah.
So what sort of things have you seen, I guess, with the police contact, if you?
Seeing various substance abuse issues and whatnot, and then getting a handle on interpersonal interactions between people.
Sure, okay. So in some of those interactions where there's been alleged substance abuse going on, how did that make you feel?
I'm just there to provide medical care, so I try to do that to the best of my ability, and that's really all my job is, so.
Okay, so knowing that and seeing those things, do you feel that, I guess, people with substance abuse issues, addicts who are out there, that they are, treated, they should be treated any differently, one way or the other?
I mean, it doesn't matter when it comes down to it. It's if you need medical attention, regardless of if you're a frequent flyer or not.
Sure, okay. But I'm gonna push you a little bit more. So kind of taking off your EMS hat, right? Kind of putting on your personal hat. How do you feel about that?
About whether or not they deserve help or.
Well, not help, but like, how do you feel about like just the interactions that you've seen?
Well, if you're interacting with someone who's intoxicated, you can't really assess how they are not intoxicated because your time with them is so limited.
Okay, all right. Well, thank you for sharing that with me. Sorry to put me on the hot seat.
Sure.
Great, thank you. I don't have any more questions.
Thank you. I think we are peremptory challenges, Ms. Robinson.
Yes, Your Honor. The defense would like to thank and excuse juror number 2.
So Mr. Williams, Jaden Williams?
Yep.
All right. So thank you for your appearance today. You're excused.
You're welcome.
And we'll replace juror number 2 with Timothy Torka. Sure. Sure. Right. I think they probably want to get paid. All right, so it's been brought to my attention that and we should pay you, all of you, okay? That's the one thing you should do is you should get paid today. Our treasury office closes at noon. So I'm gonna put you in the responsibility of Ms. Kneeling, and we're gonna go downstairs and make sure that everybody gets paid for their service, and then we'll bring you back up and continue. I'm afraid that if we don't get you there before noon, you'll have to wait for your payment, and that's not fair to you because you're taking up your time to be here. So, and that doesn't work for anybody. So let's take an adjournment of the voir dire process, make sure everybody gets paid, and then we'll come back and finish it, okay? All right, thank you. All rise for the jury. You follow Ms. Kneeling, she'll take you to the Treasury Department. We'll make sure everybody gets what they're supposed to. All right, we'll stand in recess until the jury gets back. Thanks.
Yeah, just go down the hallway, or you can take her stairs, the stairs. Okay.
Oh, yeah.
That's insane.
I'm sorry.
What you doing down here, Dave?
It's me and you, Aaron, hanging out.
Ride or die.
Like the old days.
Thanks, Dave.
All right, take care, Daniel.
So, Aaron, what you think? This one. I think they got a strong case.
She didn't say anything.
I have a biology healer that I have to keep going back up. Well, you don't want it to look like you're having too many.
Right. Yeah, I feel you. So this case, he went to the hospital because he was detoxing from alcohol. He's there for 11 days, experiencing hallucinations, ETs, all that kind of shit. In the process, he apparently punches a nurse in the stomach. Nurse is saying it was clearly intentional. He's like, I don't even remember her. I don't know who she is. And like, she then continued to treat me afterwards. You know, his wife was there and said that he needs to be restrained because he's done this before, like because when he gets violent and has seizures from that kind of stuff. He was saying like stuff like saying his wife was the nurse and like a bunch of stuff, and he wasn't even able to like walk or stand on his own. You know, I thought we should have resolved this to a stupid jostling with fines and costs.
Yeah, that part.
But he was like, no, he can plea as charged or we go to trial. And I'm like, well, that's not enough. So guess we go to trial.
Add another L. You know, I mean, yeah, maybe looking to break the streak out.
Yeah, I don't know, but he doesn't look, you know, like the greatest defender in the world. So,
Right.
so we'll see.
Oh, yeah.
It's just it's dumb. It shouldn't be an assault and battery. It just shouldn't be.
No, nothing like that.
And he was willing. He's like, yeah, I'll play with that. That's fine.
I know back in my early 20s, mid 20s, alcohol did a lot of things.
Right.
So, you know,
For
I
sure,
got
dude.
a lot of fights back in the day, drunk, don't even remember what the heck happened.
Right? God. Those times in college where you just like wake up the next morning and you're like, where am I?
Yeah.
What happened?
Right.
Who are you?
They could have added another character to the Hangover movie. I'm like, they should have called me. I thought I had some more stories from them.
Right. Oh my God.
Yeah, that's not intentional. I mean, clearly out of mind.
Yeah. She's gonna say like he said some stuff to her and then punched her and whatever, but it's like, yeah. If you look at it like just in that context, but I think like looking at the whole picture of things, like, can you really say that? I don't know.
Right. I mean, especially when somebody's under distress like that.
Right. I mean, he was admitted for 11 days. Like that's like heavy drinker.
Oh yeah.
You know,
yeah,
like that's not like I just have a hangover kind of stuff. So
yeah, that I don't know. So moments when you kind of want to pick your battle because if they think like me, I'm like, well, if you're drunk, what you expect? You know what I mean?
Right.
If he got a history of drinking, that's probably his normal behavior. Not saying it's right, but I mean,
yeah. Have you guys been to trial recently? Or landlord-tenant bullshit?
Yeah, I actually would rather have a trial than deal with that.
You're like, I want to be at trial every week if I
Yeah.
can not have to do landlord-tenant day.
Well, the last guy had, he kicked himself out after he cussed us out and went all the way. Got out by the elevator, jumped in my face once. I said, look, I don't do physical contact. Stay in your space. You know, I'm not here to fight you, but at the same time, you're not gonna keep walking up to me. Because he did it 3 times.
Right.
He walked in my face. I'm like, dude, that's your last time. I'm telling you to leave. So they finally security grabbed him. And then we found out from Whitty, oh yeah, I should have called you guys. He threatened to shoot the process server that was serving paper. So you didn't think to tell us today.
Right.
That we should, you know. Yeah. So of course he did his normal. He called and complained about me and Judge. He said we yelled at him.
Okay. All right. Well,
Okay.
did you deserve it?
Yeah.
Next question,
Yeah.
right?
We were nice about it. We should have said some other stuff to you, but you know, tried to keep it in professional perspective. But he was way out of it. He was way out of it. He's supposed to come back in July. But I told LPD, I said, you guys need to come up here. Clearly, it should have been disorderly right there. But
right.
How are you mad? You were like a whole year without paying your rent. Who are you mad at?
Right.
Who are you really mad?
Right.
Like,
exactly.
How long did you think? But they gonna pay everybody's rent forever?
Yeah.
Like,
yeah.
Work like that. I've had some people there like almost 2 years.
So it was like 3 months ago or something, but I was like sitting in here just like prepping, waiting for like the 9 o'clock to start, and he does some civil stuff at like 8:30, and there was like a hearing where this guy filed a lawsuit just to get an apology from someone. Literally like filed it and then like filed a motion. He's like, I just want an apology.
Aaron, how many motions you could file apologies? We should be filthy rich like right now.
I was just like, what?
Man, if that was the thing, can I put myself in that same
Right.
an apology?
Mhm.
Yeah.
Right.
In this life, we learn not to even expect that at all.
I'm like, oh my God, for real?
Wow, I've heard it all.
I'm like, and it's like, it's not free. Like, you have to pay to file it. You know?
Yeah.
So it's like, you're like,
Oh,
what are you doing?
Oh boy. Oh boy. See, that's the moments I'm not good at holding. My wife fusses me all the time because my facial expression, I struggle. That's why sometimes I walk out, I'm like, I can't really hide.
Yeah.
That's when I'm like, yeah, they probably held me contempt for just how I was looking at the person. God, yeah, I don't see. That's probably by far the best one. Apology.
Yeah. I was just like, wow, bro.
Like, bro, I'm still waiting for my ex-wife to apologize. I'll be dead in my grave before that ever happens. Shoot. Oh God, no. Oh, sorry.
I think let's get them all in.
All right.
Be seated. I'll bring the jury in.
Wendy and David, we're ready.
Ready, folks? You want to come on in? Follow me, please.
This is maybe one that's a team on that, you know.
You were sitting in the box, all rise.
Have the jury take back their seats. right, you can be seated. All right, just to explain, we don't usually do that, all right? But I did want to get that out of the way, but that's not our process. We were on, I believe, a new juror, correct? Juror number two. And that is Mr. Torka, is that correct?
Correct.
All right. And Mr. Torka, you had the opportunity to hear the questions that were asked of your fellow jurors. And do you have any questions in regards to, or any feedback that you think either Mr. Brodowitz or Ms. Robinson should know?
Well, my wife has worked as a registered nurse
Oh,
from 2000. She actually started at McLaren on campus.
okay.
Other side, so
So
she knows-
she's been a registered nurse for 23 years.
Well, yes.
Okay. And is anything about that, would that change your ability to be an objective juror in this case?
For that, no.
Okay. Would there be any other reason that you would have trouble being an objective juror in this case?
When it comes to alcoholism, my brother, he died from kidney failure.
All right.
At the age of 40.
So would you be able to listen to the testimony and judge credibility based on the person in front of you, not on your brother's experience?
Yes.
Okay. Would you at least try?
Yes.
All right, then that's what we ask. Everybody comes in with a framework, and we ask you to try to put that aside so that understanding we can't undo what's a part of your history, but we ask you to try to understand that you're looking at every witness as an objective entity. Does that make sense? All right. Mr. Brodowitz, any follow-up questions?
Just briefly, Your Honor. Mr. Torka, any interactions with prosecutor's office or defense attorneys? Okay. And then you said, just to kind of go over again what the judge said, the fact that your wife is a registered nurse wouldn't impact your impartiality in this case in any way?
No.
Okay. And neither would your brother's issues with alcohol?
No.
Okay.
But my other brother was arrested. Totally his wife's fault. Okay, I was called before the police arrived. Okay, and I seen with my own eyes how it was definitely my sister-in-law who was being abusive. 2 children were involved. All right, the cops came and took my brother immediately. And he was arrested. Because it's not the cop's job to make judgment, just to cool down the situation. But they had it back. She should have been the one that went.
Okay, and would that experience, impact your impartiality to either side in this matter?
No, it shouldn't.
Okay.
But it depends on what the story is, and it's kind of hard for me to believe anything I don't witness. And it's hard to believe anything I just hear from statements without actually seeing.
Okay. Thank you. Nothing else.
Ms. Robinson, any follow-up questions?
Yeah, briefly. Mr. Torka, so I know when the judge was talking to you about how with the experience with your brother and everything, right? And how he asked you to put that aside, right? So knowing that he asked you to put that aside and the law requires that you put that aside, it seems like you had maybe a little bit of hesitation.
Well,
so.
because it's not the only incident.
Okay.
Growing up in the city, I've been around people who drink. I've drank for a while in my life. I had it for years. I've seen people black out and act like idiots when they're drunk. Say they don't remember. So it's just, again, it would have to be something I witnessed to actually say one way or the other.
Okay, and so you're going to be hearing from things about alcoholism and things that might have affected. Would you use, I guess, with those things that you've witnessed, that you've seen, and maybe those events with your brothers, would that maybe creep in and affect your judgment?
Of course, because that's who I am.
Okay,
my
yeah.
life experiences. That's what I say. I can't believe anything I just heard.
Okay, so then you can't really guarantee that you could be fair and impartial in this case, and it's okay if you say no, because I mean, we're asking you to be open and honest here, right? Okay, so you think that maybe those experiences would creep in and affect your ability to be fair?
It's just, even from what you guys were talking about earlier today, the incidents leading up to his arrest. I mean, I can't be partial. I mean, I don't know.
Okay, all right, well, thank you for that information. I appreciate it. And then you also said that your wife is a registered nurse, correct?
Yeah.
Okay. Knowing that the alleged victim in this case is also a nurse, would you tend to favor their testimony more because of your wife's experience as a nurse?
No, I would not.
Okay, all right, thank you.
So we're at challenges for cause from the people.
Yes, Your Honor, I believe at this time the people would challenge your number 2 for cause.
The defense would stipulate.
All right, Mr. Tork, so we have a stipulation to that Mr. Tork is challenged for cause and stipulated to. So Mr. Torka, thank you for your appearance today. You're all set. We'll place juror number 2. So you can talk with Miss Kneeling and she will get you taken care of. We will replace juror number 2 with Devin Strunk. Is there Devin Strunk?
Yeah.
All right. So I'm gonna have you go and sit in seat number 2. You're gonna have to walk across. Yeah.
Sorry, this is all new to me.
Yeah.
Oh, okay, can we approach, Judge?
Sure. Ask questions. Just out of efficiency, let's do that. All right. So juror number 2, my understanding is you were not here during the previous questioning. Is that correct?
No, I wasn't.
All right. We're going to save you for last, okay? Rather than have the questioning, but you're not excused. You've got to sit at the back, listen to the questions that are asked. All right. But I'm going to replace you right now, just out of sake of efficiency, with another juror. Okay.
So go back over.
Yeah, go back over there, and we're going to keep you as part of the panel
Okay.
and listen to the questions asked, but we will replace Mr. Torko as juror number 2 with a Deborah Monroe. All right, Miss Monroe, same seat. And Miss Monroe, you had the opportunity to hear the questions that were asked the jury over the course of this time.
Yes.
All right. Is there anything that's come to the attention that you'd like to indicate for the record to Mr. Brodowitz or Ms. Robinson concerning the previous questions that were asked?
Well, first thing is I'm a substance use counselor at the VA. Been doing that for several years.
Okay.
Also, I did have a boyfriend die from alcoholism in the past.
Okay.
Yes.
All right. Understanding that through your life experience and your work, you've dealt with some of these issues. Are you willing to take any witness who comes to the stand as be objective and listen to their testimony and how they're confirmed or not confirmed with other evidence in order to decide credibility?
Yes.
Okay. And I'm not asking you to unlive your life. I'm just asking you to recognize that you have to look at every witness objectively. Okay. Mr. Brodowitz, any follow-up questions?
Just briefly, Your Honor. Ms. Monroe, any interactions with the prosecutor's office, defense attorneys, anything like that that would make you impartial to one side or the other?
No.
Okay. And then any friends or family that work in the medical field?
No, sir.
No other questions, Your Honor.
Ms. Robinson, any follow-up?
Yeah, just briefly. Ms. Monroe, good afternoon. I think it's past 12 now, right? Any of the questions that I asked stuck with you in particular? Anything that's like made you think like, yes, no, like strong opinions about either way? Okay, so knowing that this case involves some issues surrounding substance abuse and knowing your background and everything, do you think that's going to cloud your judgment at all?
No.
Okay. And I know the judge already asked you about with what happened with your boyfriend, and I'm so sorry that that happened. Do you think that maybe hearing about this kind of stuff could possibly trigger anything for you that would cause you to be fair or not fair and impartial, affect your ability to reach a verdict? No. All right, thank you. Nothing further.
So I think we are at,
At the
that was a
state
stipulated challenge for cause. So I guess we could go challenges for cause, Ms. Robinson.
None at this time.
All right. Preemptory challenges with the people. Just one second.
At this time, the people would like to thank and excuse juror.
Juror number 2. All right, Ms. Monroe, you're all set. Thank you for your appearance today.
Thank you.
And you can meet with Ms. Nealing. So we will replace Ms. Monroe, juror number 2, with Gerald Hernandez. And so I'm going to have you stay right there, sir. Counsel, can you approach?
Yes.
So Mr. Hernandez, just in regards to sitting and listening, you've had some trouble hearing, okay? I've talked to counsel. We're going to stipulate that you don't have to serve as a juror just because I think the auditory portion of this is going to be so difficult. Do you understand that, sir? All right. And that's pursuant to stipulation with counsel. So you can meet with Ms. Nealing and you're free to leave, okay? Thank you. All right, so we would replace juror number 2 with Daniel Bryan. Mr. Bryan, you have to go over everybody to get to seat number 2. I didn't design this courtroom, so.
Let's go here at least.
Right. We had one juror just accuse us of constant musical chairs, which is very true in some way. Mr. Bryan, you had the opportunity to hear the questions that were asked of your fellow jurors.
Yes.
Is there anything that either party should know concerning any of those questions?
I do have 2 cousins who are nurses. I don't feel that will have an impact on my reasoning. I have also had 2 friends pass away from substance abuse in the last year, and 2 others who overcame substance abuse in the last few years. Again, I don't feel like that will have an impact on my ability to rationalize this.
All right. All right, Mr. Brodowitz, any further questions, follow-up questions?
And just briefly, Your Honor, Mr. Bryan, any interactions with prosecutor's office or defense attorneys or anything that would make you impartial to one side or the other?
Not that would make me impartial. However, I should say that as a state employee, I used to work with the Attorney General's office on a fairly regular basis, as well as the court system when I was with the my season desk.
Okay, but you think that would not affect your impartiality, you know? Okay. No other questions, Your Honor.
Ms. Robinson, any follow-up questions of the new juror?
Yes, briefly. So having some of those people who are close to you that have gone through those substance abuse sort of issues, do you mind sharing a little bit about how that affected you personally?
My friends died.
Yeah, and I'm sorry to hear that.
Was a emotional stressor, to be sure. But also seeing friends and helping friends that have overcome, in particular, alcohol addiction, that it was an emotionally taxing thing to go through.
Sure.
More the worse for them, I guess, but having to actually live it.
Sure. But that doesn't take away any sort of trauma that you experienced from that as well. And so knowing that there's going to be maybe some testimony that comes up that talks about substance abuse and alcoholism, is that going to maybe trigger some things for you that might cloud your judgment?
Not at all.
Okay. And tell me about working with the Attorney General. What did you do there?
Specifically, I work for the Department of Technology Management and Budget.
Okay.
I do information technology support initially for the state police, for the Criminal Justice Information Network, which court systems use and whatnot. Presently, I work now as a analyst doing server support for the Departments of State, Corrections, and Police specifically.
Okay. So it sounds like you do more of like IT type of
Yeah,
things.
that occasionally I help them with trying to get their systems working if they're having trouble accessing digital evidence every once in a while. Computer crimes people call, need support that.
Okay. So were you ever involved in like prosecuting or anything like that, or it was
Nothing
more
that-
just like technical sort of thing?
Nothing that would ever put me in a courtroom.
Okay. All right. I think that's all I have. Thank you.
All right, so I think we're on preemptory challenges with the defense.
Briefly, can you give me a brief moment?
Sure.
Thank you. Your Honor, the defense accepts the panel as is, subject to all previous motions and objections.
Thank you. So the defense accepts the panel. So we have a panel. You are our jury, a jury of 7. So so I will have any remaining jurors to follow Ms. Kneeling. And what the plan is right now is to go ahead and read instructions and go into opening statements and then take a break for lunch, okay? And that'll get you coming back just for the testimony, okay? So any other jurors can follow Ms. Kneeling?
All rise.
All right, you can be seated. And we'll go ahead and pull up our procedural instructions before we do opening statements, okay? Ladies and gentlemen of the jury, you've been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. I will now ask you to stand and swear to perform your duty to try the case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. So please stand, raise your right hand or affirm. Each of you do solemnly swear or affirm that in the action now before the court, you will justly decide the questions submitted to you, that unless you are discharged by the court from further deliberation, you'll render a true verdict, and that you will render your verdict only on the evidence introduced in accordance with the instructions of the court, so help you God. All right, you may be seated. You'll have a written copy of the instructions I'm going to read you. You may refer to them during the trial. Since no one can predict the course of a trial, these instructions may change at the end of the trial. At the close of the trial, I will provide you with a copy of my final instructions for use during your deliberations. Now I will explain some of the legal principles you will need to know in the procedure we will follow in this trial. To prove the charges, the prosecutor must prove each of the following elements beyond a reasonable doubt: that the defendant is charged with assault or assault and battery, that Melvin Eugene Cornell committed a battery on Teresa Spencer, parentheses, Hayho. A battery is a forceful, violent, or offensive touching or the other person, or if something closely connected with a person of another. The touching must have been intended by the defendant, that is not accidental. It must have been against Teresa Spencer Hayho's will. It does not matter whether the touching caused an injury. That the defendant intended to either commit a battery upon Teresa Spencer parents Hayho, or to make Teresa Spencer parents Hayho reasonably fear an immediate battery. A person accused of a crime is presumed to be innocent. This means you must start with the presumption the defendant is innocent. This presumption continues throughout the trial, entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements, which I've just read to you. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or do anything. If you find that the prosecutor has not proven every element beyond reasonable doubt, then you must find the defendant not guilty. Every reasonable doubt is a fair, honest doubt growing out of evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of the case. A trial follows this procedure. First, the prosecutor makes an opening statement where he gives his theories about the case. The defendant's lawyer does not have to make an opening statement, but she may make an opening statement after the prosecutor makes his statement or may wait until later. These statements are not evidence. They're only meant to help you understand how each side views the case. Next, the prosecutor presents his evidence. The prosecutor may call the witness to testify and may show you exhibits like document or objects. The defendant's lawyer has a right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of his evidence, the defendant attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has a right to cross-examine the witnesses. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Like the opening statements, these are not evidence. They're only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as a judge in this trial are to make sure the trials run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. It is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you have based on the witness's race, national origin or ethnicity, gender identity, sexual orientation or religion, age, or socioeconomic status. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to make an honest effort to tell the truth, or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, or suggestions or any influences that affect how the witness testifies? In general, does a witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does a witness's testimony seem when you think about all the other evidence in the case? When it's time for you to decide the case, you are allowed only to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The questions the lawyers ask the witnesses are not evidence, only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. I may ask some of the witnesses questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, you may think of an important question that would help you understand the facts in this case. You're allowed to ask such questions. You should wait to ask questions until after a witness has finished testifying and both sides have finished their questions. If you still have an important question after this, do not ask it yourself. Raise your hand, write the question down, and pass it to the court staff, who will give it to me. Do not show your question to the other jurors. If your question is not asked, it is because I determined under the law that the question should not be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about the facts of the case, nor should you speculate what the answer might have been. Also, in considering the evidence, you should not give greater weight to testimony merely because it was given in answer to questions submitted by members of the jury. If you cannot hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand immediately. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of the case. Sometimes the lawyer and I will have discussions about out of your hearing. Also, while you're in the jury room, I may have to take care of other matters that have nothing to do with this case. Pay no attention to these interruptions. You must not discuss the case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all the jurors are there. You must not talk to the defendant, the lawyers, the witnesses, or anyone who may be connected to this case. This means you may not speak to these individuals, even if it has nothing to do with this case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to this case. This restriction is necessary to avoid even the appearance of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, tell them to stop. Explain that you are a juror, you're not allowed to discuss the case. If they continue, leave, report the incident to court staff as soon as you return to court. When the trial is over, these restrictions no longer apply. When the trial is over, you may, if you wish, discuss the case with anyone. For our purposes, in our afternoon, you'll have a different court officer in regards to the afternoon instructions, okay? The restrictions I'm about to describe are meant to ensure that parties get a fair trial. In our judicial system, it's crucial that jurors are not influenced by anyone or anything or anyone outside the courtroom. Under the law, the evidence you consider must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because information obtained outside the court does not have these safeguards, it could find you incorrect or misleading information that might unfairly favor one side. These restrictions start now and continue until I discharge you from jury service. It is your duty to decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspaper, on television, the radio, the internet, or on social media platforms. You must also not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, cellular phones, computers, or other electronic devices. You must not visit the scene or any event at issue in this trial. It is necessary for you to view or visit the scene. Court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge you have of the scene. You must not share any information about the case by any means, including cellular phones or social media. This means that even if you are not discussing the case with someone else, you may not post any information about the case on social media websites or in any other manner. If you discover that a juror has violated my instructions, please report it to staff. You may take notes during the trial if you wish, but of course you don't have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the jurors see them during deliberations. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. You can see we have chosen a jury of 7. After you've heard all the evidence and my instructions, we will draw lots to decide which one of you will be dismissed to form a jury of 6. So after closing instructions and summation or closing argument, one of you will not deliberate. We have one extra juror, okay? That's either the best day or the worst day, depending, okay? Possible penalty should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by the law. I may give you more instructions during the trial. After all the evidence is presented, you will hear the lawyer's closing arguments. Follow the closing arguments. I will give you additional instructions about the ruling. Following the closing arguments, I'll give you additional instructions about the rules of law that apply to this case. You should consider all my instructions as a connected series. Taken all together, they are the law you must follow. After my final instructions, you will go to the jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It is important for you to keep an open mind and not to make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not fully aware of some of our other biases. Take the time you need to test what might be automatic or instinctive judgments and reflect carefully about the evidence. I caution you to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives than your own. All right, and with that, we will go into opening statement from the prosecutor's office.
Thank you, Your Honor. Good afternoon, everyone. Thanks for bearing with us for all this time. And I know it's been a long morning for everybody. But we're here today because we've heard a lot over the last few years, especially through the pandemic and all of that, about how healthcare workers especially are essential workers, how we need to, thank those healthcare workers, how they put their lives on the line during the pandemic to take care of us. The victim in this case, Miss Teresa Spencer, formerly Hayho, is one such person. She's a nurse who works at McLaren. The people will prove through evidence that while she was performing her duties, simply just doing what she was supposed to be doing and taking care of the defendant, Mr. Cornell, that Mr. Cornell rolled over and deliberately punched her in the stomach for no reason other than her doing her job. The people expect that the evidence will show that that he intended this act, that this was a deliberate act, and that this caused great pain and discomfort to Ms. Hayho for quite a while after. People intend to prove this beyond a reasonable doubt through the testimony of Ms. Teresa Hayho and her coworker, Mr. Gregory Deachin, who was also there at the time. And after you hear that evidence, the people would ask you to find the defendant guilty as charged. Thank you.
Thank you. Opening statement defense.
The state wants you to think this is a cut and dry case, but they haven't told you everything about what the evidence is going to show. This case involves Mr. Cornell going to the hospital to get treated for detoxing from alcohol. He was in the hospital for 11 days. 11 days. He was in the ICU. His wife was visiting every day to come and see him. You're going to hear testimony from the nurse in this case that Mr. Cornell turned over, deliberately punched him or punched her in the stomach. But there's going to be more in this case that shows that maybe that act wasn't so deliberate. You're going to hear from Mr. Cornell's wife, Ms. Dodson, and she's going to tell you about how he was acting those 11 days, how he was experiencing hallucinations, he was having seizures, how he didn't recognize his own wife. She's also going to tell you how he wasn't able to stand and move and walk on his own. You're going to hear all of those things. So keep an open mind, listen to all the evidence as it comes in. And I think you'll ultimately come to the decision that Mr. Cornell is not guilty.
All right, opening statements have been indicated. I think before we take any testimony, maybe we'll give you the lunch break, all right? You probably deserve more than anything right now. Payment and a lunch break at least. But we'll do that, and then I would say, so the court officer is not my regular court officer. This is Judge Buchanan's court officer. But David is, what's your full name, David?
Warrensley, I'm sorry.
What's that?
I almost forgot my last name, Warrensley.
David Warrenson, he's going to be responsible for the afternoon of getting you in the correct. So you should meet Mr. Warrenson at, I'd say, 1:45 in front of the jury room. Okay, so I'll let you go to lunch on your own. Get back, because we'll probably start taking. I have a 1 o'clock docket and a 1:30. We'll probably start taking testimony at 2. So get here about 1:45. Okay. All rise for the jury, and you're dismissed for lunch. Be back here about 1:45. All right, you may be seated. All right, anything to come to the court's attention? We're planning on coming back about 1:45 and then starting around 2. Opening statements are done. We'll provide witness testimony at that and after 2 o'clock. Anything from the people?
Nothing from the people, Your Honor.
Ms. Robinson?
No, Your Honor, thank you.
All right, thank you. So we're adjourned in this matter till, I'd say, 2 o'clock.
And Judge, just for purposes of the calendar, Ms. Vacone from my office is coming over to handle the 1:30 stuff. I know that you have a 1 o'clock, but I don't think that's our case.
Right, I think that's just a restitution hearing.
Okay.
Mr. Carter.
With Mr. Carter, right. It's Mr. Warrenson.
Warrensley.
Warrensley.
Yeah, just I forgot when I'm like, what is my last name?
I forgot your last
I
name
got
too.
stuck. I'm like,
I know. I forgot your last name too. That's why I didn't introduce you. So
To just be back here by
Yeah.
1:35 if you see
my
your face is great.
Yeah, because I was like,
what's your last name? But I was going to introduce you as I indicated that you're in charge during the afternoon, and all of a sudden I'm like, I don't know David's. I don't think I know David's last name. I can't think of it.
just
Yeah.
I guess we can start with the sentencing, so we can start with Mr. Henderson.
Henderson? Good point, Ms. Bruce Savage. So we're on the record in a docket 22-03028. That is People of the State of Michigan versus Travis Henderson. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Your Honor, Assistant Public Defender Melissa Vachon on behalf of Mr. Henderson, who is present standing to my right.
And sir, you are Travis Eugene Henderson?
Correct.
All right. This is the time is set for sentencing today. Mr. Brodowitz, just to begin with, is there any restitution in the matter?
People have received no restitution, Your Honor. However, the victims here would like to make a statement.
Okay.
To the court when the time comes.
All right. Ms. Vachon, have you had the opportunity to go over the pre-sentence report with your client?
Yes, Your Honor, there are no corrections.
Okay. All right. Allocution, Ms. Vachon.
Yes, Your Honor, I know Mr. Henderson is, regretful on how this night with his daughter turned out. I do believe that a term of probation would be helpful for him, and that the batter's intervention class specifically will help him, gain more tools that he can use when interacting with his family members, Your Honor. I would request that he not be required to submit to random PPTs or urinalysis tests. I don't believe that there are any allegations of alcohol or drugs being involved in this instance. And it's certainly not a problem for Mr. Henderson. He is working full-time and concerned about being able to make those tests and the payments as well, Your Honor. Thank you.
Thank you. Mr. Henderson, is there anything you'd like to say to the court before the court passes sentence?
I wish everything went differently.
Mr. Brodowitz, you have a individual wants to make a statement to the court?
Yes, Your Honor.
The victim? Or a statement? Do they wish for you to read or do they wish to read
No,
it
I think
themselves? All right, you can come up here. All right, ma'am, you are?
Kiara Henderson.
Okay, and you wish to make a statement to the court?
Yes.
Concerning sentencing, go ahead, ma'am.
Should I just read like my victim impact statement or?
Yeah, however you choose. If you want to read your impact statement, that'll be fine. If you just want to tell me what you're thinking, that'll be fine too.
I'll just read it. The events that happened on September 25th are something I would never imagine. For as long as I can remember, my dad was the person I looked up to, my favorite parent. Me and my mom never really got along. So I would talk to my dad about everything, even as a child. He taught me a lot, ranging from how to ride a bike and to never count on anyone's words. My parents divorced. I was 10. I went to live with my mom. She had primary custody. We'd go week on, week off though. Going to my dad's house was like a vacation for me. I was going to see my favorite person, and I quickly changed. As about 2 years went on, he moved to Battle Creek. At first, he was consistent, picking up me and my sisters every other weekend, but suddenly it stopped. He started ignoring our calls, and on our pickup days, he wouldn't show up, which really broke me and my sister's heart. We'd go about twice a month, and each weekend was filled with yelling and fighting over my dad and his girlfriend. He seemed lost. He was drinking a lot. I never seen him drink more. With that, some key behavior changes. Fast forward to about 2 years ago, he moved back to Lansing. He kept his routine with getting us every other weekend. He would come to school events and take me to work whenever I needed a ride. But in all, he still didn't seem like himself. He was more irritable, angry, and irrational to the point where I no longer wanted to go to his house. For the few times I was with him, it always ended up in either me or my other sister getting into an argument with him. Fast forward again to August, his side of the family was having a reunion in Gary, Indiana. I had a legitimate excuse as to why I did not want to go. I had work the next morning at 9 a.m. My mom was trying to make me go because I did not want to have company over. As a result of that, she kicked me out. I ended up with him. I was stuck with the man I was trying to avoid. We were fine for the most part, besides some bickering here and there, although the big issue started when I refused to buy toilet paper for the house. I was in between paychecks, and all the money I had left was to go to Ubers for work. He then texted me that same night asking me to buy toilet paper, and I said no. He then told me to find my own ride home, so I did. After that, his energy towards me completely shifted. Everything turned negative. While my younger sister was at work, it's only me and my little sister cares. He noticed that the box of muffins in the trash were all gone. He asked my little sister nicely if she was the one who ate the last pack. She said no. In return, he then immediately started cussing me out and saying that they were his and I shouldn't have eaten them, although there has been food that I bought that he has eaten. I replied something along the lines of, I don't care and it shouldn't matter. He then came in my room and started screaming in my face. My little sister started crying and asked him to stop. I went to reach for my phone to call my friend Lyric to come pick me up. My dad thought I was calling the police and started getting more aggressive. I explained to him that I was just trying to call Lyric, and he left for a second and came back. He told me that he didn't want me there anymore and to get all my stuff. Every attempt I tried to make to move, he was pushing me and blocking me. He ended up pushing me on some tires that were in the room. Soon, a fight ensued. I went to grab my phone again at this time, just threatening to call the police so he would stop. I wasn't going to. That angered him more. He grabbed me by the throat and threw me down on the bed. He was trying to wrestle me for my phone. I was scratching him so he could get off. He finally did. I lost possession of my phone and he grabbed it. He then ran off and locked himself in his room. I kicked the door to try to get it back. He blocked me from entering. A few minutes later, he finally gave it to my sister. I then called the police. I just wanted a safe way to get out of the situation. I didn't want for any of this to go down. I was displaced after that. I went with my older sister that night. That was only temporary. My heart felt like it shattered. I would never thought that my dad, out of all people, would have been the one to do something like this to me. He was supposed to be the one to protect me, but I still love him so much. I know that this isn't him. My dad just needs help right now. That's why I say he's no gym time. I say he needs a mandatory counseling. He needs to be there for my sisters, do better for them. My younger sister is going into her senior year this year. He needs to be present. My littlest sister is going into her freshman year. He needs to be present. He needs to do better for himself. And I believe that he can soon be better.
Thank you. Ma'am, have you had the opportunity to read the recommendation today?
No.
Okay. Well, this sentencing is in regards to, and I did have the opportunity to read the victim impact statement that was along with the pre-sentence report. So this sentence is in regards to a guilty plea of domestic violence in the second degree and a guilty plea of attempted interference of electronic communications. I've seen the JOS and the following of the pre-sentence report. I find it fair, full, and accurate, and so I'm going to follow it. I'm not going to change it in any way, but what that means is that the court carries an enormous hammer right now, okay? I'm not concerned about your performance. Well, that victim impact statement speaks for itself. I'm not concerned about your performance in the next 12 months, okay? The next 12 months, you follow what probation orders or else you're gonna end up in jail. That's the rules, okay? I'm more concerned 3 or 4 years from now, okay? As you know, you never stop being a parent, and right now, it's more important than ever for you to heal some of these wounds, for whatever they are. I'll leave it at that. Suspend 365 days in jail beginning June 13, 2023. Credit is given for 2 days. I'm suspending 363 days, so full year upon successful completion of probation. So I'm keeping the 363 days, okay? I'm going to enter a order of $250 fines, $250 costs, with a crime victim's rights fee of $75, a state minimum court cost of $50, probation of $360. for a grand total of $985. There's also a state minimum cost fee for $50 on the second file, which would be $1,035 can be paid over the course of probation. Probation's ordered for 12 months at $30 a month, which is part of the totals. You are to have, at least at this time, until I hear differently for probation, and until we get over some of this initial part of the case, no contact with the victim, Kiara Henderson. You're to be within 2,000 feet of where she works, resides, lives, goes to schools, without consent of the court or an order of probation. No assault or threatening behavior, no use of possession of alcohol, marijuana, or controlled substances. I'm going to submit you to random PBTs in your analysis as directed and paid fees by the probation department. Some of this is based on the pre-sentence report that indicating that you have had bouts that you have gone with alcohol, and that seems to be reviewed. No bars or nightclubs. Batterers intervention services and pay fees are part of the completing the rehabilitative services. Obtain and maintain employment as required, which you've done. Not purchase or possess firearms, ammunitions, or weapons of any kind. And then other comments which are part of the sentence, mental health counseling as directed and pay fees. So that's the order of the court. The only update as to the fines and costs. Mr. Henderson, you have more than just your own personal welfare in regards to this sentence, okay? You certainly hold the lives of anybody you've parented and your children in this case. I hope you reflect on that. I hope you prioritize that. I think you are a person who knows that. You've indicated that you understand the allegations have been made. And I think it's time for healing to begin on some level. But I can't control that. I can just control the next year. After that, 3 to 5, 6 years from now, I truly hope that you look back and take this as a learning experience, something to learn from, than something to be angry at, because I think healing needs to begin right now. With that understanding, that's the sentence of the court on docket 22-02-828. Anything else, Mr. Brodowitz?
Nothing from the people, Your Honor.
Mr. Sean? Anything else? Okay, you're all set, sir. You should stop by probation on the 5th floor and get this process started. They'll set up an outline. You're all set.
Hold on one second.
All right, there is Mr. Henderson. Next we have, which one, Mr. Savage or Mr. Wozniak?
Savage works here.
All right. So we're on the record in docket. We're on the record in docket 23-00947. That's people of the state of Michigan versus Christopher Allen Savage. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Melissa Vachon on behalf of Mr. Savage, who is present standing to my right.
And sir, you are Christopher Savage?
Yes, sir.
All right. Is the time set for a sentencing in the matter? Mr. Brodowitz, just off the bat here, are there any restitution? Is there any restitution in this file?
Not to my knowledge, Your Honor.
Okay, thank you. Ms. Vachon, have you had the opportunity to go through the pre-sentence report with your client?
Yes, Your Honor, there are no corrections or changes.
Thanks. Allocution, Ms. Vachon.
Yes, Your Honor, I know Mr. Savage regrets how this night turned out. He is working hard to turn his life around. He no longer associates with the people he was with that night. He's, different. He hangs out with a different crowd now, and he's looking for employment. He told me that he is submitting applications on Indeed. He also has employment lined up to begin next month if he's not able to find anything sooner than that, Your Honor. And otherwise, I do believe that the recommendations are appropriate.
Thank you. Mr. Savage, is there anything you'd like to say to the court before the court passes sentence?
No, sir.
All right. Mr. Brodowitz, any comment or any victim in regards to this case?
Nothing, Your Honor.
All right. This is in regards to count one, a guilty plea of possession of loaded firearm in a vehicle, a misdemeanor charge. At this point in time, the court is going to suspend any upfront jail and give credit for 2 days previously served. I'll suspend 30 days on successful completion of probation. The fines and costs on this misdemeanor matter will be $100 fine, $100 costs. Crime victims' rights fee is $75, state minimum court of $50, and probation of $180 for a grand total of $505. I find the judgment of sentence to be full, fair, and accurate. I do think that it indicates the opportunity to put this behind you. You're not a kid, but you've got to deal with the consequences of the misdemeanor. So probation for 6 months at $30 a month. No assaultive or threatening behavior. No use of possession of alcohol, marijuana, or controlled substance without prescription. Submit to random PBTs and/or urinalysis as directed by the probation department. No bars or nightclubs. The only thing they really ordered for this, besides the submission of random PBTs, is the moral recognition therapy. I think that that's probably a good idea. Okay, so let's go ahead and do that. The submission moral recognition therapy. You're working on your employment, so that's already half the battle is to work on it. Not possessed, so I'm going to order, obtain, and maintain employment. No purchase of possession of firearms, ammunition, or weapons of any kind. And that's the extent. 6 months probation. If you do what that can be a fast 6 months. All right. And I think that's the key here to get this behind you. You look like you're going on the right track. And as you know, we can be influenced. I know this as good as anyone by the people we hang out with. Yeah. And so that's a major step in the right direction. Okay. So with that understanding, you can stop down on the 5th floor and check in with probation. Just make sure that you've got things in order for them. Do you have any questions of me concerning your sentence, sir?
No, sir.
All right, Mr. Brodowitz, anything else for the people on docket 23-00947?
Nothing on behalf of the people, Your Honor.
Ms. Vachon?
No, Your Honor.
All right, good luck to you, Mr. Savage.
Thank you.
And then we have Mr. Wozniak. And counsel, I have this as a sentence. Is this a normal sentence or on a probation? I do have restitution here, but well, we'll put it on the record just so. So we're on the record in docket 22-01856. That's people of the state of Michigan versus Gerald Wozniak. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Elizabeth Vachon on behalf of Mr. Wozniak, who is present standing to my right.
And sir, you are Gerald Wozniak?
Yes, sir.
All right. This is the time set for a sentence in this matter. This was sentenced on a disorderly person. Mr. Brodowitz, is there any restitution in this matter? And this looks like this was set for a restitution and control date. Is that correct?
That was not I'm looking, I don't see any restitution in our file, Your Honor.
Okay, I have restitution of $407.12. Would you like to see that, sir?
Yes, please.
Here. David, can you take that over to?
Yep.
Yeah. I believe. Yeah, this was. Okay. Yeah, I believe that was all in the. It actually.
So is that your understanding? The restitution is ordered to Sparrow Hospital, $407.12.
Yes, now that I remember.
Right. This is sentencing. I don't have a pre-sentence report.
No, Your Honor, I believe as part of the negotiations, and I'm not sure if it was ever referred to probation or not, but part of the negotiations between myself and Ms. Sutter were that the sentence terms, well, at least there would be a recommendation to probation that non-reporting probation and that the terms be consistent with the defendant's current orders from CMH.
All right, so so now it's sentencing, do we want it to go to probation for any type of supervisory act? I guess I'm a little confused by, because or did you just want I've got it set for sentencing date. I know I have the restitution in order. I have continued CMH counseling, but I don't know if that was supposed to be supervised or unsupervised.
According to my notes, it was supposed to be non-reporting.
Okay, so non-supervised.
Yes.
All right. So we have fines and costs and no upfront jail, and then continue with CMH.
Yes, Your Honor.
All right.
That would be the.
All right. Is that your understanding, Ms. Fashan?
Yes, Your Honor.
Okay. So Ms. Fashan, allocution on your behalf.
Yes, Your Honor, I just requested the court follow the plea agreement. I do believe that Mr. Wozniak is doing much better now. He told me that he is in sober living at Endeavor House Ministries. He also is complying with CMH. He visits, he goes there every other week, and he will continue to do that, Your Honor. If possible, I would ask that he be allowed to do community service in lieu of some of the monetary amounts owed in this case, as he's not permitted to work while living in sober living.
Okay, thank you. I think that's a fair request. Anything you'd like to say, Mr. Wozniak, to the court before the court passes sentence?
No, sir.
All right. So we have a plea to disorderly person. On disorderly person. I'll follow the Killebrew agreement and indicate that continue following whatever CMH orders, continue your work in that regard. I'm going to waive fines and costs in this matter. I have a $75 crime victims' rights fee and a $50 state fee that goes towards $125. That what we'll do is we'll set it out sometime so you can pay it on your own at your own time frame. Okay, so we'll set it out probably about 4 months, and then you can set up your own installment plan to pay it. But that's the only thing, and those two I can't waive. All right, fines and costs are waived. It doesn't make. I'd like to do community service. I just don't know how to supervise it if he's not on probation. Yeah, he'd have to go to probation in order to supervise the community service. I'm reluctant to put him on probation. It doesn't seem like the answer to this as we started out here.
Your Honor, I think he'll be okay with just paying the overtime thing.
All right, I think that's probably preferable so what we'll do is it's continued work, it's completed disorderly, which you have. So the judgment of sentence is the $125 to be paid. So we'll make it July, August, September, October. So by October 13th, let me make sure that's a regular date. Yep, it's a Friday. October 13th, 2023. By 4 o'clock, that $125 should be paid to the city of Lansing. Okay, that should give you 4 months to figure it out, and get on your feet. The priority here is your continued work with CMH. Okay, that's kind of the underlying theme here, and I think that's how's that been going for you?
Good.
Okay, I think as long as you stay within that whatever they order, I think you'll be fine. It's when you stray from that these things start to happen. Okay, I think you understand that. All right. So $125 will be paid by October 13th, 2023. That is the judgment of sentence. Continued work with CMH, but I'm not going to put him on probation. And order of restitution, yeah, we've got to order the restitution to Sparrow Hospital. And we'll set a 6-month date for that, okay? So that's 6 months out as opposed to, well, let's just put it all together, okay? So let's put the $125 along with the $407, just so it's easier for that. Dollars plus the $407 restitution. So that's $532. $532.12. And that should be paid by, we'll make it December 13th at 4. And what this does is it gives you 6 months to get everything in order and then to make payments to the city of Lansing, and those restitution payments will come out on top. So they'll take those first, but it lets you set up your own installment plan. Okay. You put 25 towards it, 40 towards it, 60 for it. As long as it's all paid by December 13th, you should be all set. Okay, sir? Anything else for the record? Docket 2201856, Mr. Brodowitz.
Nothing from the people, Your Honor.
Ms. Vashon. All right, you're all set, Mr. Wozniak. Good luck. Did you? Good, because that one was not like any other one.
Yeah.
There's no program.
Yeah, you started to say probation, and then you started to
No.
type. You know how I get.
You got 407. All right, good. This is perfect. So I'm gonna put in big letters CJOS
Okay.
because I tried to write what I did and I probably made it worse.
Yeah, I heard you start to say probation. I
Yeah,
just kind of went
that's
with
not gonna
that.
work. All right. I'm gonna put a big circle around CJOS. All right. All right. Ms. Robinson, are you ready to bring the jury in? All right.
Your Honor.
Oh, I forgot about Skeen. Let's do Glenn Skeen. Mr. Carter's not here and Mr. Skeen is not here. Is that correct?
That is my understanding, Your
All
Honor.
right. And this was set on a controlled date to see if we had a number for restitution. Is that right?
Yes.
Do we have so I'm going to call to the record docket 22-03307 and 23-00641. That's people of the state of Michigan versus Glenn Skeen, with the understanding that Mr. Skeen is incarcerated, is my understanding.
I believe so.
Yeah, and Mr. Carter was waiting for a number. And so we set this as a control date. Do we have a number at this time?
I have not received, I know the victims were contacted during the pre-sentence interview by probation about it, and I've tried reaching out to them and had no contact as late as last night about any sort of restitution number.
All right. So I'm going to indicate for the record that we do not have a restitution number on this matter at this point in time. The court will not order restitution. And that was the only thing left of this sentence, I believe. Was we extended this just to see if we could get a number for restitution purposes from any of the victims, and we were not able to.
You're working close to that administrative excellence.
Yeah, so without restitution, I'll administratively close both files. That's all for the record in docket 22-03307 and 23-00641. Now, are we ready to bring in the jury?
Yes.
All right.
Before we start, Your Honor, there is a service dog again in the courtroom. I'm not sure how
As long as the dog sits by the witness, and if there's no objection to that being the.
Well, I have an objection because there
Okay.
wasn't a notice filed.
There was no notice filed. There was no. I don't think counsel knew of this.
Sir, hold on.
Okay.
Sir, hold on.
Are you a witness, sir?
No, he is not one of my witnesses.
All right. All right.
I also had no prior notice of the.
So,
service
so
dog.
there's a service dog in the courtroom, but it's not part of witness testimony. All right, so let's have, so it is an open courtroom. Is the dog in the courtroom right now?
He's right here,
Yes.
sir.
Okay. It is an open courtroom. It is a valid service dog. It's not a support animal.
Nope, he's certified through the state of Michigan. He's an extension of myself.
All right. So I don't think we have to file a notice or anything along those lines.
That's fine, as long as it's not.
Yeah, it's not a witness. It's not a part of the circumstance. So I think it's allowable. All right. For some reason, I was under the impression it went with a witness. It doesn't.
No.
So I think just proceeding as we have been is fine.
Okay.
All right. I think we are to treat the animal as an extension of the person. I think that's the best way to say it. With that understanding, anything else to be brought to the court's attention before we get started, Mr. Brodowitz?
Nothing from the people. Your
Ms.
Honor.
Robinson?
Your Honor, thank
All right,
you.
Mr. Cornell, you can come up here and we will bring the jury in. All rise for the jury, please. Mr. Carter's here. If you want to email him.
Oh, nice sit down.
He's a little late. About 40 minutes.
That's David time. Actually, an hour and 10 minutes.
Right, you can take your original juror seat. Right, you may all be seated. Jurors, I hope you've had a decent lunch. We'll start with proofs. Mr. Brodowitz, you may call your first witness.
Judge, we would invoke the rule at this time. I do think there's other witnesses.
Are there any other witnesses that are going to testify in the current trial in the courtroom?
There is.
All right, then they have to leave. All right, thank you, Ms. Robinson. Mr. Brodowitz, you may call your first witness.
Yes, Your Honor, the people would call Ms. Teresa Spencer.
All right, Ms. Spencer, I'm going to have you come up right up here in front of me. I'm going to have you state and spell your first name and last name for the record.
Teresa Spencer, T-E-R-E-S-A.
Okay. Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right. Have a seat here, and please project to the back because for recording purposes. And Mr. Brodowitz, when you're ready.
All right. And then Ms. Spencer, just like the court said, they are recording everything, so we need verbal answers, yes, no, no, uh-huhs or head shakes or anything like that, so. Okay. All right, sorry. Good afternoon, Ms. Spencer. Ms. Spencer, where do you work?
McLaren Greater Lansing. I keep here.
All right. So move up right next to the microphone. And as long as the jury and the recorder can hear you, I think you'll be good. All right. So ask that question again.
Ms. Spencer, where do you work?
McLaren Greater Lansing.
All right, and what's your position?
I'm a nurse.
All right, and are you assigned to any sort of special unit there, or just?
I work on 9 East.
Okay, and what specifically happens on 9 East?
Everything.
Okay, so there's no, just to clarify, there's no specialty or anything, just general practice.
Cardiac, respiratory, ventilators.
Okay.
That's it.
So as a nurse at McLaren, what do your job responsibilities typically entail?
Taking care of the patient, assessing vitals, monitoring them, administering medications.
Okay. And then were you working in that capacity on December 14th, 2022?
Yes.
Okay. And on that date and time, were you, working with a patient by the name of Mr. Melvin Cornell?
Yes.
All right. And you had Well, first of all, I should ask too, you said you worked at, just to back up for a second, you said you worked at McLaren Hospital, correct?
Correct.
And that's located in the city of Lansing?
Lansing.
East Lansing or Lansing? Is that, I guess, let me,
It's on Collins Road, 2900 Collins Road.
okay. And is, I guess I should ask it this way, is that a East Lansing or Lansing mailing address?
I don't know.
But that's located in Ingham County?
Correct.
All right, and so going back to where I was on that, on December 14th, 2022, did you have a patient by the name of Melvin Cornell?
Yes.
Okay, and do you see Mr. Melvin Cornell anywhere here in the courtroom?
Yes.
And can you identify where he's sitting in an item of clothing he's wearing?
A black champion sweatshirt.
All right, and where is he sitting?
Right.
Okay, please let the record reflect the witness has identified the defendant.
Any objection to the witness identifying the defendant?
No objection.
Without objection, the witness has identified the defendant.
Okay. So if, I know if you can answer, I know there's certain things, but what, on that date, what was Mr. Cornell being treated for?
Alcohol withdrawal.
Okay, and how long had you been treating Mr. Cornell?
That day was day one that I took care
Okay, and to the best of your knowledge, if you know, how long had he been at McLaren?
of. I don't know.
Okay. So on that date, what specifically, just one second, yeah. So on that date, what specifically were you doing to, I guess, help treat Mr. Cornell?
I was treating his anxiety, his agitation.
Okay, and how, if you can, for the jury, can you describe his demeanor on that day?
He was alert, oriented, fully aware of his surroundings and what was going on.
Okay, and you said you were trying to treat his anxiety. How were you doing that?
Administering Ativan,
And what is Ativan?
a benzo,
What?
benzodiazepine.
Okay, and what does that medication do?
It decreases anxiety
Okay,
and helps relax the patient.
okay. And so, did there come a point in that day when you were trying to administer that to Mr. Cornell?
Yes, he requested it and I tried to give it to him, but apparently I was not fast enough.
Okay, and when you say you weren't fast enough, can you describe that?
His agitation increased because it took him longer than 3 minutes to go get it.
Okay, and what happened after that? After you you got the Ativan and you returned to the room, what happened?
I was administering it and he continued to get increasingly agitated, tried to get up out of bed, and I can't get him out of bed while I'm administering medications. And so he reached over and punched me in the stomach.
Okay, and when you say, I mean, it may just be academic, when you say he punched you in the stomach, was that, closed fisted?
Yes.
Okay. And if you could just, I guess, indicate sort of for the jury where he punched you, if you could just show them.
Straight in the abdomen.
Okay, and let the record reflect the witness indicated the abdomen just above, I guess you'd say the belly button.
Good. The record may so reflect.
Okay. And after Mr. Cornell punched you, what happened after that?
Other staff members came into the room. He looked directly at Greg and told him that he wasn't going to do the same thing to him because he was too big.
Okay, and when you say Greg, who are you referring to?
My coworker.
And what's
He's a
his?
nursing assistant.
Okay, and what's his full name?
Gregory Deachin.
Okay. And was Mr. Deachin in the room at the time that you were punched?
He was in the doorway.
Okay. And so after Mr. Cornell punches you and he says that, what do you do after that?
I called a code gray.
And what's a code gray?
It's a code that's called to call in security, other physicians because of aggressive behavior.
Okay. And after you called in the code gray, what happened?
then there was more medications that were given. He was given a dose of phenobarbital.
And what was the phenobarbital?
Increases agitation.
Okay. And did you administer that or did someone else?
I did.
Okay. And after that was administered, did his agitation decrease?
Yes.
Okay. And then after he was administered that, what happened?
The plan was in place to send him to the ICU for one-to-one nursing for aggressive behavior.
Okay. And then did you ever, on that date specifically, did you ever contact the police?
We did.
Okay. And did the police come and take a statement?
They did.
Okay. And then after that, did you ever treat Mr. Cornell again?
I treated him the next day for a couple hours before he was transferred to the ICU.
Okay. And then I guess did he spend the rest of his time at McLaren in the ICU, or did he ever come back up to the ninth floor?
I don't know what floor he came back to, but he wasn't in the ICU for the remainder of the time.
He wasn't?
No.
Okay. Did you ever treat him after he was let out of the ICU?
No.
Okay. No further questions, Your Honor.
All right, cross-examination, Ms. Robinson.
Yes, Your Honor. Good afternoon, Ms. Spencer. You stated previously that Mr. Cornell was admitted for alcohol withdrawal, correct?
Correct.
So some of the symptoms of alcohol withdrawal can include hallucinations, tremors, seizures.
Correct.
Have you treated patients with alcohol withdrawal before?
Yes.
Okay. And do they all act the same or do they act differently?
They're all different.
Okay. And so how do some of them act versus, well, I guess tell me how the different interactions look.
Well, they usually will request medications when they can feel their anxiety increasing, but I've never had any other alcohol withdrawal patient throw a punch.
Okay, but that wasn't my question. So I guess I'm just asking, what other things do you observe from people who are going through alcohol withdrawal?
Vomiting, diarrhea, sweating profusely.
And sometimes they have hallucinations, correct?
Correct.
Okay. They can have tremors.
At times.
Okay. And they can have seizures, correct?
At times.
Now, when he was there, he was admitted for alcohol detox, alcohol withdrawal, otherwise known as. So that requires someone to have been very heavily drinking, correct?
Yes.
Okay. So somebody who simply like has a hangover or had too much the night before, or I guess even a couple nights in a row would not go to the hospital for that. Oh. And you said that he was given Ativan, correct?
Correct.
Okay. And that was before this incident as well?
It was throughout his stay, he was given Ativan.
Okay. So, and you said Ativan is a benzodiazepine, correct?
Correct.
Okay. And usually it's used for anti-anxiety or control of anxiety type conditions.
There's lots of uses for Ativan. But
Sure.
yes, that is correct.
Okay. And typically when people are going through alcohol detox, are they prescribed benzodiazepines like Ativan?
Yes.
Okay. And do you know why that is?
To prevent them from having seizures and to keep them calm.
Okay. Now, so with Ativan, it does prevent anxiety, or that's, I guess, the therapeutic use of that drug, correct?
Yes.
Okay. But sometimes there's contraindications to that therapeutic use of that drug, isn't there?
Yeah.
Okay. And so sometimes there can be called what's like the reverse effect, can't there?
Yes.
And the reverse effect is when people get hyper agitated, correct?
Correct.
So, you stated that you weren't aware how long Mr. Cornell was in the hospital for on the day of the incident, or excuse me, for his entire stay, correct?
Correct.
Okay, but this was your first day treating him on the day the incident occurred?
Yes.
Okay, and immediately after the incident, after you called in the code gray, did you remain his nurse for the entirety of your shift?
Yes.
Okay, so you continued to treat Mr. Cornell.
Yes,
Did you have any interactions with Mr. Cornell's wife at all?
yes, occasionally.
Okay, and did she ever tell you about Mr. Cornell's history? Okay,
Yes.
I'm sorry. They just need the yes or no for the court reporter. So if we stop you, that's why. So she did tell you a little bit about his history before.
Yes.
Okay, did she tell you about the fact that he needed to be restrained before?
No.
Okay, so she never told you that?
No.
She never told you about how when he's detoxing from alcohol, that he can get agitated and upset?
Correct. She said that.
Okay, so she did tell you that.
And that's when I explained to her, that's why we give them the medications that are prescribed.
Okay. And at that point in time, was there, well, let me back up. So as you're treating him, he's in a hospital bed, correct?
Yes.
Okay, so he's not up, moving around, walking.
He can get up and he can move around, but at that specific moment, he was not.
Okay, so you said he can, but he was in a bed that time.
Correct.
Okay, so just because he can get up doesn't mean you saw him get up, correct?
I seen him get up occasionally.
Okay, but he wasn't getting up at that time.
He was getting up, like sitting up and moving to the edge of the bed.
Sure, but I guess I mean like walking around, doing that sort of thing. Okay. Prior to the incident, did you have any interactions with Mr. Cornell?
Throughout the day, I was his nurse from 7 a.m. till 7 p.m.
Okay. Did he ever mistake you for his wife at all?
No.
Now, I know we talked about the Ativan and the reverse effects of that drug, but do you know if he was on any other medications at the time?
I don't recall.
Okay. So you weren't aware if anything else was being administered at the time?
I'm sure he had other medications, but I don't recall what they were.
Okay. Let's see. You said when the incident occurred, he was getting more and more agitated, that I guess you weren't, hurrying up with getting the medication, correct?
Yes.
Okay. And that when you tried to reach over the bed to administer it, is when he allegedly punched you, correct?
Correct.
Okay. And so were you on the side of the bed that was closest to him, the side of the bed that was far away? How did that look?
I was on the right side of the bed with his IV access and his IV medications that were hanging.
Okay. Are you aware of what DTs or delirium tremors are?
Yes.
Okay. Can you explain a little bit about that, what they are?
Very comfortable.
Okay. Does that happen when people go through alcohol detox?
Sometimes.
Okay. Do you know if Mr. Cornell was experiencing those effects?
Not severe.
Okay, but he was still having them.
Yes.
Okay. Part of the things that can happen with delirium tremens include hallucinations, correct?
Correct.
Okay. They can also include delusions.
Correct.
People can say things, have conversations with people, may not know what's going on, correct?
Correct.
And where you work at McLaren at the hospital, do you know if there are surveillance cameras?
I believe there are surveillance cameras in the hallway.
After this incident occurred, did you seek any sort of medical attention at all? So during, you said, I want to go back a little bit, but during your shift, you said that you finished your shift out treating Mr. Cornell. And then you came back for another shift and you treated Mr. Cornell as well. Is that correct? Okay. And then that's when he was moved and he was no longer on your floor? I have nothing further.
Redirect, Mr. Brodowitz.
Very briefly, Your Honor. So, Ms. Spencer, you said during testimony that you were you're familiar with seizures, correct? Okay, and in your experience, and in this instance, was what happened to you consistent with what you've seen in terms of seizures?
He wasn't experiencing a seizure.
Okay. So then you also, you're stating you administered Ativan. Have you administered Ativan prior that day?
Yes, multiple times.
Okay, and how often is Ativan typically administered?
Typically every hour to every 2 hours to every 4 hours, depending on the situation and severity of the assault.
Okay, and just off chance, do you remember how often or how recently before this you had given Ativan?
Just giving it every 3 hours or so.
Okay. So defense also asked how he was behaving. Did you ever, in your treating of Mr. Cornell, did you ever see him up and around and walking around the room?
I seen him ambulate to the bathroom.
Okay.
And prior to me administering the medication, I assessed his orientation and he was alert and oriented, knew where he was at, and knew what was going on.
When you say you assessed his orientation, what do you mean by that?
His name, his birthday, the date, the time, where he was at, and the reason why he was in the hospital.
Okay. And then after Mr. Cornell punched you, did you experience any pain or anything like that?
Discomfort.
And how long would you say that lasted? Do you remember?
About 24 hours.
Okay. No further questions at this time, Your Honor.
Just for my edification, you were originally Teresa Cahill and now you're Teresa Spencer?
Correct.
Okay, thank you. Anything else for this witness? Mr. Brodowitz, made this witness be excused.
I would just like to reserve this witness for possible rebuttal, Your Honor.
All right, may she be excused now?
Yes.
Ms. Robinson, any further questions or can this witness be excused for now?
No, she can be excused.
All right, so witness, the prosecutors asked that you stay for rebuttal. You can wait outside, but your testimony is excused for right now. Thank you.
Thank you.
And Mr. Brodowitz, you may call your next witness.
Yes, Your Honor, the people would call Mr. Gregory Beach.
Mr. Deacham, you can come right up here. You stand right in front of me and state and spell your full name for the record.
Gregory James Deachin, GREGORYJAMESDEACHIA.
Okay, please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? I do. Okay, have a seat. Please project for recording purposes. That's a mic that'll go to the recorder. So if you want to move up to that mic, it doesn't amplify, but it'll allow the recorder to hear you.
Okay.
And Mr. Brodowitz, you may proceed.
All right. Good afternoon, Mr. Deachin. Mr. Deachin, how are you employed?
I am a nursing assistant at McLaren, Greater Lansing.
Okay, and McLaren Greater Lansing, is that located in the city of Lansing in Ingham County?
Yes.
Okay. And then what do your duties at McLaren entail?
I'm a nursing assistant, so I help the patients with their everyday ADLs, assist with their bathing, taking to the bathroom, linen changes, gown changes, help feeding.
Okay. All right, and were you working in that capacity on December 14th, 2022? Okay, and on that date, did you have interactions with a patient by the name of Mr. Melvin Cornell?
Yes.
And do you see Mr. Cornell here in the courtroom? And can you identify where he's sitting and an article of clothing he's wearing?
Over here to my left with the champion flag video.
Please let the record reflect the witness has identified the defendant.
Any objection to the witness identifying the defendant?
I would kind of object because he just kind of pointed to him before.
But I think
Yes,
that,
the question, I don't think it's a big deal, but
so is there an objection?
there's no objection.
Without objection, the witness has identified the defendant.
All right, and on December 14th, 2022, what caused you to have interaction with Mr. Cornell?
Well, on our floor, we have patients that are going through detox or unsteady or confused. On our floor, we have what is called a bed alarm. And this gentleman was going through detox, very unsteady on his feet. So we had a bed alarm on him. So anytime he would try to get out of bed, the alarm would sound and we'd go in the room to make sure he wasn't getting out of bed to harm himself or anything on that nature.
And to the best of your recollection, how often did you have to go into his room with the bed alarm?
I want to say quite often.
Okay.
Every,
Go ahead.
at least 10 minutes or more.
Okay. So you had occasion see, and did you see during that time, did you ever see Mr. Cornell up and walking around, or was he just mainly trying to get out
He
of
was
bed?
just trying to get out of bed.
Okay. Did you ever see him actually get out of bed?
In his stay, yes.
Okay. Specifically on that day, or?
I don't recall if I watched him stand up on that day or not.
Okay. And on that date, were you working, did you have an occasion to be in Mr. Cornell's room with a nurse at that time known as Teresa Hayho, not Teresa Spencer?
Yes.
And why were you in the room when Miss Spencer was in there?
Well, the alarm was going off, so anytime an alarm goes off, our nature is to go to the room, make sure they don't harm themselves, fall. And the alarm was going off, so that's why I entered the room.
And did you observe anything when you entered the room?
Yes.
What did you see?
I was standing by the doorway, which is probably here to that first bench away from the bed where Teresa, Mr. Cornell was, the bed is.
So you'd say that's from here to the front when you're talking about the first
And
about 15 yards?
No, not 15.
no, maybe
Just to that first bench there.
All right.
about 15 feet, maybe.
If-
Yeah.
Okay, so let the record reflect the witness. The bench is about 15 feet away.
Okay. And what did you see on that date?
He was trying to get out of bed. He was at the foot of the bed, trying to get out of the bed, and Teresa was standing at the foot of the bed as well, trying to talk him into not getting out of bed because he was very unsteady on his feet. He didn't
Okay.
want him to fall or anything. And he proceeded to throw a punch at her and hit her in the stomach.
Okay, and when you say he threw a punch at her, how would you describe that?
He was at the foot of the bed and he kind of with his right hand swung at her in that nature.
Okay. And after you saw Mr. Cornell punch Miss Spencer, what did you do?
I run up and got in between the two of them. Teresa stepped back and he fell into the bed and looked at me and says, "Oh, I'm not gonna punch you, you're a big pepper."
Okay.
And laid back and closed his eyes.
All right. And then after that, what happened?
After that, their security team was up there and there's a bunch of people. Then I kind of just stayed there in case anything else happened.
All right. And then from what you observed on that date, how would you describe Mr. Cornell's demeanor?
He was very antsy, continuing, wanted to get out of the bed, wanted to leave. And just constantly up and down, trying to get up and down.
Would you describe how would you describe his level of alertness?
For the most part, I think he was oriented.
Okay.
But with detox, there's moments of clarity. So
Okay. No further questions, Your Honor.
Cross-examination, Ms. Robinson.
Yes, Your Honor. It's Mr. Deachin, right?
yes.
Okay. Thank you. You stated that on the day of the incident, you were kind of going into Mr. Cornell's room every 10 minutes or so because of the alarm going off. So did you treat Mr. Cornell like on any days prior to this incident?
I'm not positive if I did before or not.
Okay, so you just don't remember that. But on this day, you said that he was unsteady on his feet, correct?
He was unsteady, yes.
Yeah, oh, unsteady, yes. If I was unclear, I'm sorry, I apologize. But yes, he was unsteady on his feet. And so when you went in,
I didn't say on his feet, I said he was unsteady.
okay, so he was not on his feet, but he was unsteady.
Correct.
Got it. So was he shaking?
He was shaking, he was on his hands and knees at the foot of the bed and barely keep
Okay.
that pose.
When did he ever try to have any like conversations with you at all during this time when you were treating him? Okay. So he wasn't, trying to ask you how your day was or anything like that. And then when you went into for this incident, you stated that when he woke up, he threw his hand, and then he immediately fell back into bed after saying he wasn't going to punch you, correct?
Correct.
Okay, and he closed his eyes. So was he asleep?
Sure.
Okay, but he was
Just closed his eyes.
was he responsive after that?
I didn't have a conversation with him, so I'm not sure.
Okay. And so you stated that also he appeared to be oriented, but sometimes when people go through detox, they can have moments of inclarity.
I'm not a doctor, I can't answer that question.
Well, that's what you said, correct?
He had that, but I can't clarify if that's.
I'm not asking you, I'm just asking you in general.
Yes,
Not exactly what was going on with him. But so in general, people can appear to be oriented 1 minute and then appear to not be with it the next minute, correct? Okay, and that's just symptoms of alcohol detox, correct?
Sure.
Just need an answer out loud for the court reporter. After this incident, did you continue to treat Mr. Cornell, or was that it?
We continue to monitor him.
Okay,
I didn't have any contact with him after that.
okay. But you weren't specifically assigned to him after that?
I don't recall if he was in my section or not. I
Okay.
just know when their alarms go off, we go to the room, whether it's our patient or not.
Nothing further.
Any redirect, Mr. Radowitz?
Just one second. No further questions, Your Honor.
May this witness be excused, Mr. Radowitz?
Yes, Your Honor.
Ms. Robinson?
Yes, Your Honor.
Witness, you're excused. Thank you for your appearance today. Mr. Brodowitz, your next witness.
At this time, Your Honor, the people have no further witnesses. The people would rest their case unless there is necessary for rebuttal.
All right. So the people rest. Does the defense, do you want to make a motion now? You can save your motion if you choose to.
I'll save it.
Okay, and then, so the people's case is over, and the defense, you may call your first witness.
The defense would call Ms. Krista Dodson.
All right, Ms. Dodson, if you come up and stand right in front of me. Okay, please state your first name and your last name and spell them both for the record.
Krista, Krista, Dotson, Dotson.
Okay, please raise your right hand. Do you solemnly swear or affirm to tell the truth, whole truth, and nothing but the truth under penalty of perjury? All right, please have a seat here. Please project to the back for recording purposes. And that mic right there will project right to the recorder. So that,
Right here?
right there. Yeah.
Okay, thank you.
All right. Ms. Robinson, you may proceed when you're ready.
Hi, Ms. Dodson, how are you?
All right.
Can you explain how you know Mr. Cornell?
He's been my husband for 17 years.
Okay, and back in December of 2022, was there ever a time that he was admitted to McLaren Hospital?
Yes.
Okay, do you know what he was admitted for?
For alcohol dependency, with a very strong case of getting delirium tremens from stopping completely on his own.
Okay, and explain how he was acting prior to going to the
He
hospital.
couldn't walk. We actually had to borrow a wheelchair from the neighbor to even get him downstairs our apartment. His dad had to come and help him because I couldn't do it by myself. Yeah, it was bad.
Okay, and so going to the hospital, well, actually, let's back up a little bit. So Mr. Cornell, is he an alcoholic?
Oh, I'm sorry. Yes.
Okay, and how long has he struggled with alcohol?
Probably on and off for 20 years.
Okay, has this been the first time that he's gone through the withdrawal process?
No. This
Okay.
is the third time, just because alcohol is a disease. So it's been a hard thing for him to get. His son passed away. I don't know if that has anything to do with it, but that's why he relapsed this last time. So his son was only 25.
I'm sorry to hear that.
Thank you.
So after him relapsing this time, or previous times of him going through and having these issues, can you explain how he acted in those previous times?
Yes, he's not himself. When he gets the medication that normal people take, it doesn't work the same way because his dependency is so high. He doesn't know who he is. He doesn't know where he's at. He's very agitated, aggressive. Since he doesn't know where he's at, he doesn't understand. People are trying to help him. Most of the time, he doesn't even know who I am. He actually was in a sober living and escaped and was running in the snow with a t-shirt and shorts and no shoes and didn't even know what he was doing. So.
All right, so when this relapse occurred, you did what any wife would do. You took him to the hospital, right?
Well, his dad did, just because we have a young son.
Sure.
But his dad called me and told him that Mel told him he was there for seizures, not for alcohol. He's like, Krista, please call back up there and tell him why he's really here. And I said, that's fine. So I called the emergency room. I said, my husband was just admitted. He doesn't know what's going on. He's there for alcohol dependency. And they're like, we did not know this. I said, I know, that's why my father-in-law told me to call you. I told them then that first day, an hour after he was admitted, he's gonna get aggressive. He's gonna get agitated. I've seen it happen
Your
twice
Honor, at this
before.
point, I would object to hearsay.
Response?
That's okay, Your Honor, I can move on.
All right. So the objection sustained.
So I don't want to go into what
Right.
his father said, but have you ever seen Mr. Cornell act aggressive when he's been
Yes.
detoxing before?
Yes.
Can you explain what that looks like?
The first time we went, we didn't even know what delirium tremens is. I don't know if you want me to explain what delirium.
You can
tremens-
explain in your words what you believe they are.
Delirium tremens is a something that happens to the brain when the medication and you don't have alcohol anymore and the medication stops working for the patient and they really go delirium. Like they don't know what's going on. He didn't know who I was. We were in the room at the emergency room the first time back in Grand Rapids, and he's looking under the bed for alcohol. He saw cats running down the hallway. He kept telling me to take him home because he didn't know where he was, and then he would tell me that he was at his mom's house, and then he was telling me to grab the Captain Morgan out of my purse. Like, give me the Captain, give me, babe, I don't have any Captain. Like, I don't have any Captain. So he's just completely out of his mind. And I've seen him get aggressive because he got aggressive with me when I was there. So the nurse actually pulled me out and said, just give him a minute to relax because he's very, very, very agitated right now.
So on the date of this incident back in December of 2022, Mr. Cornell was admitted to the hospital, correct?
Yes.
Okay. And did you ever speak with any of the medical staff at McLaren?
Everybody from the first floor all the way until he was admitted. I told him he's already been in restraints for, he's ran
Yeah,
away.
Your Honor, I would object to hearsay.
Response?
No, it's not hearsay. She's telling.
Yeah, I've seen him.
Okay.
Okay. What she says out of court is hearsay. So she's the declarant, she's available to cross-examination, but what she says to other people is still hearsay. If she said in the form of a question, it's not offered as an assertion, but what this witness said out of court is a hearsay.
Well, I'm using it to show notice, Your Honor. So to show that they were given notice of what was going on.
Sounds like
State of
it's,
mind.
sounds like it's in the form of a question, so it's not an assertion, so I'll allow it.
Okay. So you can continue.
Oh, is there okay? Okay. I want to get in trouble.
Okay.
I just want
I know
to
you're
make
new to
sure that people understand that I did try to do my part to tell him that he needs to be restrained, like for everybody's safety. And the day before this happened, he was very agitated. I went to the nursing station, probably so much where the nurses were like, oh my God, is she back here again? Because I was so worried about him doing something to somebody, doing something to himself. He just was not in the right state of mind.
Okay. And did you ever, back in December, did you ever go and visit Mr. Cornell in his room?
Every day.
Okay. And did he recognize who you were then?
Not at the beginning, no.
Okay. Who did he think you were?
So, no, he didn't know who I was.
Okay.
So, and I'd have to tell him. And then there was another nurse that he kept calling my name.
Okay. And so this was going on throughout his stay, correct? How
Yes.
long was he in the hospital?
11 days.
Okay. And during that time when you would visit him, you stated that he wouldn't necessarily recognize you. Would he be aware of what was going on?
No, not really. I mean, those first couple of days, no. And a lot of those times he was knocked out. So he was sleepy most of the time.
Okay. Did you hear him or any other bizarre behaviors during his stay when you were there watching him?
Just him trying to get out of the bed, even though he couldn't walk, over and over and over and over again. Like I couldn't get him to stop. And that was the day before the incident happened. So that's why I was so nervous about leaving. But like I said, we have a 14-year-old at home, so I had to get home.
Sure. I don't have anything further. Thank you.
Cross-examination, Mr. Radowitz.
Just briefly, Your Honor. Good afternoon. So you stated on direct that you were at the hospital every day, correct? And were you?
Is that a yes, ma'am?
I'm sorry, yes.
You're fine.
And were you there all day?
Not all day, no. I was just starting a new job and we were moving and we had a 14-year-old at home. So not all day. I would stay like 2 to 3 hours every day.
Okay. And were you at the hospital on December 14th at the time this happened?
No.
So you don't have any personal knowledge of what his state of mind would have been at that time?
I left him that night, so I know how bad it was that night. And I went to the nurse's station and warned them about this.
Now, when you say that night, about
It
what
was
time?
probably 8 o'clock, 9 o'clock at night.
Okay.
The
what was
hospital
that?
never informed me that this happened because I gave them my number and I told them I'd come back if there was any emergencies. And I was never.
So you visited after this event happened?
Yeah, I wasn't
Okay.
told about it. I came to visit at my normal hours and was not even aware that this happened.
Okay. No further questions, Your Honor.
Any redirect, Ms. Robinson?
Just briefly, you stated that you visited him after the incident, but you also visited him beforehand.
Yeah, yeah.
And you
The
spoke,
day, and I just wasn't there in the middle of the night, and I think it happened in the middle of the night.
And you spoke with nurses as well before the incident, correct?
Yes, yes.
Nothing further. Thank you.
May this witness be excused, Ms. Robinson?
Yes, Your Honor.
Mr. Radowitz?
Yes, Your Honor.
All right, you're excused. Thank you for your appearance today, ma'am.
Okay, thank you.
And does the defense have any further witnesses?
Your Honor, if we could take maybe a brief 5 to 10 minute break.
Sure. So we'll adjourn for 5 to 10 minutes. All rise for the jury. We'll adjourn 5 to 10 minutes and come back with either additional testimony or instructions. So you can follow the court officer to the deliberations room. Mr. Wormsley.
Thank you, Judge.
But have a seat, and we're on the record in 23-00380. Ms. Robinson, I understand you want a little time to
Yes,
consult with
please,
your
thank
client.
you.
But just in regards to, did you have any motions, perfunctory motions or motions otherwise in between the plaintiff's case and the defense?
I did not.
All right. So with that understanding, there were no motions in between, and Ms. Robinson graciously, she could have interrupted and we could have gone through the whole
No,
thing,
that's
but
okay.
she indicated that we'd wait till we had a good time to stop. So I'll let you consult. I'll work on the jury instructions and then we'll decide from there, okay?
Sure, sounds
All right.
good. Thank you. All right.
Miss Robinson, let me know the courtroom, okay?
Sure, thank you.
Let me stop the recording.
Well, on my end.
They want to hear all that.
Sure, and testified, right? She can say, right, oh, I can go with you. No, she can say
No,
that.
she's been excused.
Yeah,
Yeah, she's been excused.
Yeah.
I couldn't.
All right, jurors, if you retake your seats. You have one rebuttal witness, Mr. Brodowitz here, so she may want to exit well with the anticipation that she still might testify.
Yes.
All right. With that understanding, you may all be seated. Robinson, do you have any further proofs today?
I do, Your Honor. The defense would call Mr. Melvin Cornell to the
All right,
stand.
Mr. Cornell, you can step right up here, right in front of the bench. And please state your first name and your last name, and please spell them both.
Melvin Cornell, Melvincornell.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right, please have a seat. Project for recording purposes, and that mic right there, if you talk into that mic, the recorder can hear you. It's better.
Yes, sir.
And Ms. Robinson, when you're ready.
Thank you. Hi, Mr. Cornell. How are you?
I'm all right.
A little nervous?
Yeah.
That's okay. I know you kind of heard everything of what's been going on, but do you struggle with alcohol?
Yes.
Okay. Can you tell me about that?
It's been going on for years.
Okay. And back in December of 2022, when this incident happened, were you sober or were you not sober?
I tried to detox myself at home, and then I started having seizures, so I had to go to the hospital.
And prior to going to the hospital, how much were you drinking?
Like a fifth a day.
So you then went to the hospital because you said you were experiencing DTs, correct?
Yes.
Okay. Can you tell me what that felt like, how that looked?
I couldn't walk, and I was starting to have seizures, shaking, like sweating. I tried to do it myself and couldn't.
So did you go to the hospital voluntarily, or did they take you?
My dad comes got me.
And so you went to the hospital. Do you remember going to the hospital?
I remember going in the ER and sitting on my bed, and when I went back in the bag, I remember that.
Now, how long were you there?
11 days.
Do you remember, besides, I guess, being taken into the ER and immediately going back into a bed, do you remember anything after that?
Little bits and pieces, like I was trying to get out of the bed, I was trying to go home, and then not much after that.
Okay. Do you remember any interactions with Nurse Spencer or Nurse Hayhoe?
I don't even know what she looked like till we seen her in court.
Okay.
I don't know that guy either. I don't know him, never seen him.
So you don't remember anything about the incident day, correct? No. Did you ever intend to hit her that day?
No.
Okay.
I don't hear one.
Nothing further.
Cross-examination, Mr. Brodowitz.
Just one second. No questions, Your Honor.
May this witness be excused from the defense,
Yes, Your Honor.
from the people?
Yes, Your Honor.
All right, this witness is excused. Thank you for your appearance, sir. Any further proofs from the defense, Ms. Robinson?
No, Your Honor, the defense rests.
All right. That ends the testimony and evidence portion of the trial. Oh, I'm sorry. Excuse me. I'm sorry, Mr. Brodowitz. Mr. Brodowitz, do you have any rebuttal witnesses?
Yes, Your Honor, the people would recall Ms. Teresa Spencer.
All right, thank you. You may recall her. All right, Ms. Spencer, you can come on up here. I will remind you that you're still under oath, all right? All right, and you can have a seat. And Mr. Rodowitz, you can reintroduce your witness for the jury. She was not excused from her testimony, so she's still under oath.
Okay. Good afternoon again, Ms. Spencer. So we heard some testimony earlier, but I would just like to ask, Ms. Spencer, what is standard policy when somebody comes into McLaren for detoxing?
Treating their symptoms.
Okay, is it standard policy to restrain that individual?
No.
Okay. Were you ever alerted by anyone that Mr. Cornell, when you began treating him, were you ever alerted by anyone that he needed to be restrained?
No.
Okay. Do you ever recall meeting a woman by the name of Krista Dodson when you were treating Mr. Cornell?
I don't remember her name, but
Do you remember meeting Mr. Cornell's wife while you were treating Mr. Cornell?
yes.
Okay. And how often would she visit?
Usually it was late in the afternoon for maybe a half hour, 45 minutes at a time.
Okay. And was that every day or?
Pretty much every day.
Okay.
The 2 days that I took care of them, she came later in the afternoon on the 14th, and then she came in the morning on the 15th.
And then when Mr. Cornell punched you, who else was in the room at that time?
Just nursing staff.
Okay. Just to clarify, Mr. Cornell's wife was not there at that time.
No.
Okay. And what time of day did this incident happen?
Later in the afternoon, between 4 and 6.
Okay.
p.m.
All right. No further questions, Your Honor.
Cross-examination concerning the rebuttal witness.
No, Your Honor.
May this witness be excused from the people?
Yes, Your Honor.
From the defense?
Yes, Your Honor.
All right, Ms. Spencer, thank you for your appearance. You're all set. You're excused from your subpoena. Any other rebuttal witnesses, Mr. Brodowitz?
And nothing from the people, Your Honor. At this time.
All right, now all the evidence is done and you've heard all the evidence in the case. So what the plan now is to give you a brief recess to send you back to the room you just came in, that tiny room, I know. And what we're gonna do is I'm gonna make sure that the jury instructions are all set. We'll bring you out here in the next 5 or 10 minutes and we'll get started with closing arguments and then the jury instructions, okay? So I'll rise for the jury and we'll adjourn for approximately 10, 15 minutes. You can follow the court officer. All right, you may be seated. And we'll take this as an adjournment. Council can join me in chambers and we'll go over the instructions. And then also we'll randomly select the extra juror.
Use the restroom.
You may be seated. So the proofs are in, and are the litigants or parties ready to proceed with the closing argument?
Yes, Your Honor.
Mr. Brodowitz, when you're ready.
Thank you, Your Honor. Thank you, ladies and gentlemen, for bearing with us. I know this is probably not what you wanted to do on a Tuesday, but thank you all the same for being here. So we heard quite a bit of testimony. And when you go back to your deliberations, I would urge you to look at each one of those witnesses, judge their credibility, and judge their stories. I would also urge you to look at the facts. We heard testimony from the victim in this case, Ms. Spencer, and we also heard testimony from the witness, Mr. Deachin, who was there in the doorway or in the room when this happened. And what did we hear from them? We heard that Ms. Spencer, formerly Hayhoe, was attempting to administer medication to Mr. Cornell to help him through his detox. And in doing so, he punches her in the stomach. This is corroborated by Mr. Deachin's testimony. That we also heard testimony from Ms. Spencer that before she administered this, she went through certain questions with Mr. Cornell and that he answered all those questions correctly and was alert. He knew what he was doing. We also heard testimony that after Mr. Cornell punched Ms. Spencer in the stomach, that when Mr. Deachin came over and entered the room, he said, whoa, something to the effect of, whoa, I'm not going to punch you, you're bigger. He knew what he was doing. The elements of assault and battery are that there was a forceful, violent, or offensive touching. We see that from the testimony. That is without question. We also need that the defendant intended this conduct. Again, we see from his own statement when he says to Mr. Deachin that I'm not going to punch you, that he knew he was punching Ms. Spencer. He knew what he was doing. Assault and battery is a general intent crime, meaning that the forceful, violent, or offensive conduct is not an accident. In this case, it was not an accident. Mr. Cornell knew what he was doing at that time, punched Ms. Spencer, who was just trying to help him. And because of that, I would ask you, ladies and gentlemen of the jury, as you are charged by the judge and find the defendant guilty as charged.
Closing argument, defense.
Yes, Your Honor. Assault and battery requires intent. It requires intent to do a harmful or offensive touching of another against their will. It requires an intent of the actor. The actor has to intend to cause the harmful or offensive contact. In this case, Mr. Cornell didn't intend to do that. Now, the state says that he knew what was happening, and that you heard this because you heard this from Ms. Spencer's testimony and that he was alert and aware, or that you heard this from Mr. Deachin's testimony because, oh, I'm not going to punch him, he's too big. But then he immediately falls back in the bed with his eyes closed. He's on day 3 of his detox at this point, on an 11-day stay, where you heard that he doesn't really remember anything besides going to the hospital and leaving. There's not really much in there. Now, I think when Ms. Spencer got up here and she testified and what she experienced, what she went through, nobody should have to go through that. Nobody should have to do that. She got hit, and that shouldn't have happened. Nobody should have to experience that, and I'm sorry for her for that. But that doesn't mean that Mr. Cornell is guilty of assault, because he didn't know what he was doing. He has no memory of the incident. He has no wherewithal or what's going on. You heard from the hospital staff, from Mr. Deachin himself, that he was in that room every 10 minutes because he was unsteady. He was on multiple different drugs, including Ativan. And you heard Ms. Spencer testify about Ativan and how that's normally used to calm people down, but sometimes it can have a reverse effect. And that reverse effect can cause agitation, as she said. You also heard from Ms. Dotson, Mr. Cornell's wife, that he's had to go and fight this battle before. And when he's fought this battle, he's become agitated during the withdrawal. That he hallucinates, he has delusions, he doesn't know where he is. He's searching for alcohol. He doesn't know who his wife is. He was looking for cats under the bed once. It's not pretty. It's not pretty when somebody goes to the hospital for alcohol detox. It's not pretty what Miss Spencer went through on that day. And I'm sure she feels violated. And that maybe Mr. Cornell was talking to her. In fact, you heard Mr. Deachin say that when people detox from alcohol, sometimes they can be alert one minute, next minute they can not know what's going on. That's the nature of alcohol detox. People just don't know. So Mr. Cornell is there. He doesn't know what's happening. He doesn't remember doing any of this act, any hitting her. He doesn't remember. There's no intent to commit this act. Because let's think about it. Why would he intend, if he was all with it at the time, why would he intend to hit his own nurse? That just doesn't make any sense. It's because he doesn't know what's going on. He doesn't know about his surroundings. And he didn't know about his surroundings at the time because immediately after the incident, after Mr. Deachin came in, he immediately closed his eyes, fell back down in the bed, and was unresponsive. And that's just the nature of alcohol detox. Now, you also heard from Ms. Dotson today and how she explained that Mr. Cornell has done this before, unfortunately, and that he's gone through this detox process before. And that sometimes he gets agitated, that she went to the hospital every day, that she informed members of the hospital staff about symptoms that Mr. Cornell will experience when he goes through this type of thing. These symptoms, these not pretty symptoms. She told people about that. She may not have told Ms. Spencer about that, but she told people at McLaren that day about what was going on. And you're right, she wasn't there at the time of the incident. She didn't testify that she was or what she saw. But she's been married to him for 17 years. She's fought this battle with him. She's seen what happens, what goes on when he detoxes from alcohol. Mr. Cornell did not intend to hit Ms. Spencer that day. This isn't a trial for disorderly conduct. This isn't a trial for loud and boisterous behavior. This is a trial for assault and battery. An assault and battery requires that intent to cause harmful and offensive contact. And we know that there's no intent because Mr. Cornell, how he acted previously, from his own statements, his lack of memory, from his wife's statements on how he acted previously, from the hospital staff's own statements on how he acted immediately afterwards and how he was acting before. How people can sometimes be aware and then not aware. So when you guys go back and deliberate, I really want you to think about everything that you heard and adding up all the pieces together. And kind of putting them in and showing what they show you. Thinking about that. Because I think it's going to show you that, yeah, Miss Spencer got hit that day. We're not denying that happened. No one's denying that that happened. And I'm sorry that that happened for her. Nobody should have to go through that. But you have to look at, did Mr. Cornell intend to do that? And I think when you're done looking at all the evidence, when you gather up all that testimony, put everything together, I don't think that the state's met their burden on that he intended to do that. And I think you'll find Mr. Cornell not guilty. Thank you.
Rebuttal argument of Mr. Brzezinski. Brodowitz. It was.
Ladies and gentlemen, the defense made a big point in their closing about there not being any intent in this matter. However, when you look at the testimony, I think you will find that that's the farthest from the truth. As I said, in the jury instruction that you will be given by Judge Flores in just a few minutes here, it says that the touching must have been intended by the defendant. That is not accidental. And when you look at the testimony, I think you'll find that that's the case. Before Ms. Spencer went in to give the medication to Mr. Cornell, she went through a bunch of questions with him where he answered where he was, the date, his name, and why he was there. He was perfectly alert to know what he was doing at that time. He then, after he punched Ms. Spencer, looked at the other witness, Mr. Deachin, and said, "Oh, I'm not going to punch you." Again, fully aware of the action that he had just taken. These are the actions of somebody who intended this behavior. This was not an accident on Mr. Cornell's part. And as the defense pointed out, yes, the testimony did say that they can be alert 1 minute and not the next. But I think, as you can see, the testimony clearly shows in here that this was a point where Mr. Cornell was alert as to what was going on. Ms. Spencer is a woman who, in her professional life, works to take care of other people. And so I would ask you, when you're charged by the judge, to go back and to take care of her and find.
Oh, objection, Your Honor. That's improper. You can't put anything that are making any sort of emotional plea for the victim.
Response?
I can rephrase, Your Honor.
All right, we'll rephrase. I'm going to. Well, the record will indicate that certainly the advocate cannot ask the jury to place themselves in the shoes of either party. With that understanding, the objection sustained, and Mr. Brodowitz, you may proceed.
Listen, I would just ask, ladies and gentlemen, that when you're charged by the judge to go back, that you hold the defendant responsible for his conduct and find him guilty as charged. Thank you.
All right. I'm going to give you the final jury instructions in this matter. So, members of the jury, the evidence and arguments in this case are finished, and I will now instruct you as to the law as it applies in this case. Remember that you've taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. That is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as it gives it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum it up, it is your job to decide what the facts of the case are, to apply the laws as I give it to you, and in that way decide the case. A person accused of crime is presumed to be innocent. This means you must start with a presumption the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. Prosecutors prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proved every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that is properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of the witnesses, the exhibits admitted into evidence, and anything else I've told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. The fact the defendant is charged with the crime and is on trial is not evidence. The lawyer's statement and arguments are not evidence. They're only meant to help you understand the evidence in each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies in this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express an opinion about the case. If you believe that I have an opinion about how you should decide the case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on race, gender, or national origin of a witness. There's no set rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might distract the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness' age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected the witnesses testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does a witness's testimony seem when you think about the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about something but told the truth about others, you may simply accept the part you think is true and ignore the rest. When you go to the jury room, you may take a long written copy of the jury instructions with you along with your notes. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a business-like way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it's necessary that each of you agrees on that verdict. In the jury room, you'll discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you are wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just the sake of reaching a verdict. In the end, your vote must be your own, and your vote must vote honestly and in good conscience. If you have any questions about jury instructions before you begin deliberations, or questions about the instructions that arise during deliberations, you may submit them in writing in a sealed envelope to the bailiff. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find the defendant actually made the statement as given to you. If you find the defendant did make the statement, you may give the statement whatever weight you think it deserves. In citing this, you should think about how and when the statement was made, about all the other evidence in the case. You may consider the statement in deciding the facts of the case. Facts can also be proven by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So taking that same example, if you see a person come in from outside wearing a raincoat with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence can be used to prove the element of the crime. In other words, you should consider all the evidence that you believe. You should not decide the case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. To prove the charges, the prosecutor must prove each of the following elements beyond a reasonable doubt. The defendant is charged with assault and/or assault and battery. That Melvin Cornell committed a battery on Teresa Spencer Parents Hayhoe. A battery is a forceful, violent, or offensive touching, or the person or something closely connected with the person of another. That touching must have been intended by the defendant, that is not accidental, and it must have been against Teresa Spencer's Hayhoe's will. It does not matter whether the touching caused an injury. That the defendant intended either to commit a battery upon Teresa Spencer Hayhoe or to make Teresa Spencer Parents Hayhoe reasonably fear an immediate battery. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on about December 14, 2022, at the location of 2900 Collins Road, City of Lansing, Ingham County. When you go to the jury room, you'll be provided with a written copy of the final jury instructions. You should first choose a foreperson. That foreperson should see to it that your discussions are carried on in a business-like way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones and other communication equipment until we recess. A verdict in criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on the verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. Possible penalties should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you are in the jury room, please have your foreperson write a note and give it to the bailiff. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know where your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. If you want to look at all of the reference documents or exhibits that have been admitted, just ask for them. I do not believe we had any exhibits in this trial, so you're basing your decision based on the testimony you heard. When you go to the jury room, you'll be given a written copy of the instructions you've just heard. As you discuss the case, you should think about all my instructions as the law you are to follow. You may return a verdict of the alleged crime of assault and assault and battery or not guilty. I prepared a verdict form listing the possible verdicts, and that is with the court officer. At this time, I will do probably the hardest thing it is to do. We will select one of the jurors who will not be deliberating as a part of this process. And through a random selection, we have selected Miss Amanda Jean Moser, juror number 6. Ma'am, you are excused for the day. Thank you for your appearance today. I'll give a second for the court officer to get back. I'll swear him in. And then when you go to deliberate, you'll start your deliberation process, okay? So, Mr. Wormsley?
Yes, sir.
All right, I'm going to swear you in. Raise your right hand. This is a long one. Do you solemnly swear that you will, to the utmost of your ability, keep persons sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made to them, or any of them orally or otherwise, that you will not communicate with them or any of them orally or otherwise except by the order of this court, or to ask them if they have agreed on their verdict until they shall be discharged, and that you will not, before they render a verdict, communicate to any person of the state of the deliberations or the verdict they have agreed upon, so help you God.
I do.
Thank you. All right, with that, Mr. Wormsley has a copy of the instructions. You can now start your deliberation process once you enter the room, okay? And then if you have any questions, you can contact Mr. Wormsley and he will contact me, all right? All right, all rise for the jury. And you can follow Mr. Wormsley. Right, you can all be seated. Where the jury is deliberating on docket 23-00380. Are there any motions that I know that Ms. Robinson, you made a motion, you made an objection during closing. Any motion based on that motion? Any motion based on that objection?
No, Your Honor, I think you did fine. You struck it and gave a limiting instruction.
All right, I think the limiting instruction was meant to help them understand the nature of the argument. And so therefore, the court is in recess during the deliberation of the jury, and I will indicate for the record that we started this process at 3:52. So the court's in recess for the deliberation.
Just don't go too far, okay?
Do you? Are we opposite?
We're off. It came us out. Mr.
Okay.
Bradowitz, do you have your jury sheets?
Right here.
Thank you.
Here's Glenn.
Thank you. I'll pop this back on Zoom.